Hi, everyone.
All right. Well, good afternoon. We are so glad to have you here. We're going to start in just a minute. So please get comfortable, get a cup of coffee, maybe a bottle of water. And this afternoon promises to be really a remarkable opportunity, and we're really glad you were here. So my name is Caroline Durham. I am the Legal and Policy Director for Georgia Appleseed Center for Law and Justice. And again, we are so excited to have you here and for this training this afternoon for the Tribunal Volunteer Lawyers Network. Student tribunal trainings are critical and important part of the work that we do at Appleseed. It, in fact, is a project that was created by the Young Professionals Council, which you will hear about a little bit later. The importance of this work, and we will talk about it more as we go forward, and why we focus on foster youth, is that the impact on a foster youth is even greater in terms of discipline issues and the way in which they are treated by the school system. The other reason that we have focused on foster youth is because when a child in care experiences a long-term out-of-school suspension or an expulsion, it is likely that they too will get a new placement for their home. So it's not just a dramatic piece within the school setting, it is also a dramatic piece within their home life. And so we want to ensure that children stay in school. We want to ensure that children have representation at these hearings. So they are getting the services. They have someone who is looking closely at their circumstance in school. And that's what we're going to talk about today, is how you can be involved in that. Before we move forward, there are a few housekeeping pieces I want to share with you. One is CLE credit has been approved by the Georgia Bar Association for 2.5 hours, and you'll get information about that in the follow-up email. I want to give you a little Zoom guidance as we go forward today. We will be sharing the presentation as it is now, and so you will have written information that we again will follow up with you on. But if you are interested in either a gallery view of the panelist or a speaker view, up to the right side of your screen, if you move your mouse, you'll see, if you're in gallery view, it will say speaker view, it will let you switch. And so we'll give you that option. There is also, when you go to the bottom of your screen and you move your cursor down, you'll see, first of all, there's a Q&A. So we will be taking questions. If you have a question, please put it in the Q&A. And we will get those to our panelists. If you have comments with regard to your question, please also be sure to put that in the Q&A. The last piece that I want to do is to put a poll up. I'm going to share a poll here to get some feedback from you initially. One is we're looking to see how experienced you are, how comfortable you are with tribunal hearings. And two is, are there different types of trainings related to the tribunal that we would like, that you would like to be engaged in? This is going to be the foundational piece of the training. And there will be more to come in the spring. And so if you've signed up for this training, we'll get resources to you. But if you'll take just a minute and give us some feedback. What is your experience with tribunal hearings? And then question two, what additional training would you like? That's going to help us build out what you need so that we at Appleseed can in fact support your engagement in this incredibly important pro bono opportunity. We'll give it just another minute or so. I'm glad to see that we've got a real variety of experience in the room here today. I think that what you're going to learn from our panelists is going to deepen your ability and get you even more engaged in the work that we have. I will say, just as a note, while the poll is up, keep an eye on your mailbox. What happens is when we get a referral from a caregiver or a DFACS worker, a Department of Family and Child Services worker saying there's a foster child facing a tribunal hearing, we do a reach out. Some of you should have gotten an email earlier this week because we were beginning to get them. Look for those, make sure you're able to respond because we want to get you engaged. All right, we'll take one more second and then we'll close out the poll. A lot of folks, it's brand new to you. We've got a couple of folks who have actually done tribunals. And so we'll close out the poll and get into our training. So thank you for your feedback. I'm going to share the results here so you can see it. Again, we've got a nice mix of experience in the room and also pretty across the board on all types of training beyond here. We will get into that when the spring rolls around. Student tribunal trainings representing children in foster care. I want to touch base for a second though on who Georgia Appleseed is, because some of you may be new to Appleseed. We are a nonprofit law firm. We are a Center for Law and Justice. And what that means is we are focused on policy reform and community engagement. And really the two big focuses that we have are dismantling the school to prison pipeline, making it so that when a child is in school, they thrive, making it so that the services that they need are there so that they can be their best. We also focus on healthy housing, bringing healthy housing to Georgia's children and families. And there is an intersection around those two issues. If a child does not have a healthy home to live in, if they are couch surfing, if they're living in a car, if they're living in a home where there's no hot water, or perhaps there's sewage coming from the unit above them, they are not going to be able to be their best selves. They are not going to be their best selves in school, which can lead to discipline issues because they're having a bad day. And so we work on both of those issues here at Georgia Appleseed, really striving to make systems change to ensure that the voices of poor people and children, other marginalized people are heard, and that we are lifting up and doing systems change from an equity standpoint. We're excited today that we're able to bring this training, and it is from our corporate sponsors, our individual donors, and then some of our grants that allow us to be able to be here with you. Verizon and HD Supply are critical to the work that we do, and also the Fulton County Board of Commissioners provides funding for this. So what are our policy priorities? Now this is 2020 and we're coming to the end of 2020. These are going to carry over into 2021. Keeping children in class and out of the criminal justice system. That's a big part of what we're going to talk about today. Providing effective interventions and supports for children with behavior challenges. So what are the school-based behavioral health supports that a child can have so they thrive? And again, the healthy housing piece, ensuring that there is low-income children and their families actually have access to safe, stable housing so that they can thrive and be their best selves. The Student Tribunal Project is, again, a creation of the Young Professionals Council of Georgia Appleseed. And again, the focus is representing foster children, children in care, who are facing tribunal hearings, which is a due process hearing, as you'll hear, when they're looking at an out-of-school suspension of more than 10 days or expulsion. Through your work with the Tribunal Volunteer Lawyers Network, you will actually represent these children who are in desperate need of an advocate to step into the setting, to say you need to see that this child is worthy, you need to see the goodness about this child, and you need to make sure, school, that you are doing ways to address the behavior that looks at the communication, because behavior is communication. There's a link here we'll share out so that you can get engaged with our project more. We've kind of touched on this. The focus is to keep children in school, provide services, and for you to bring your advocacy skills. Remember, as lawyers, there is an extra skill set that you have that needs to be engaged. So is it really a problem? It absolutely is. In last school year before the pandemic, Georgia Appleseed had more than 61 referrals for foster children facing long-term out-of-school suspension. We were able to, through the program, represent 26. We have a relationship with Georgia Legal Services where they're engaged as well. Your involvement is going to make it possible for us to do that even more. We're going to start with the child because that's what's important. And we were really honored that we've got Dr. Ayo Gathing, who is here. Dr. Gathing is a board certified child, adolescent, and adult psychiatrist. She is the real deal, and she's going to talk to you about how best to view these children, to understand your client, to understand the person you're representing who is the child. And with that, I will turn it over to you, Dr.
Thank you so much for that amazing introduction. You're too kind. So I am going to share my screen so that you all can be viewing. Hold on, let me close the chat out. Okay, there we go. Okay. So sorry. I don't see, it's not allowing me to share my screen. Oh, here we go. Okay, there we go. Sorry guys. All right, so can everyone view my screen? Can someone just say, yes, I can see it, or no, I can't see it?
We can see it.
All right. So as she said, I'm a child and adolescent psychiatrist. I specialize in working with youth in the juvenile justice and foster care system. And that is a lot of the kids that we are serving and that the tribunal process serves. And so I'm going to tell you some of the things that make them unique and some of the ways you can think about them in the future. So some of the unique experiences that these children have is that they have prior life experiences of difficulties, right? They're in the care system or juvenile justice system or whatever system because of what they've been through or what they are currently going through. So that could include trauma, multiple placements, and just not having the attention to their needs, you know, that some of your other healthy children have. Also, there's a higher prevalence of medical issues, dental issues, developmental issues, and of course, my area, mental health issues with these youth, as well as behavior problems. So these behavior problems may be a manifestation of what they're actually going through, or they might be a manifestation of an actual mental health issue. And those are some of the things we can tease out. And then as you think about some of the older kids, you might think about substance use disorders and need for ongoing treatment for these conditions, even though they're moving around or not in their primary housing situation. So there is a link to feelings of safety and permanency to mental health and well-being. So if you're receiving, you know, nurturing and advice and guidance and love and physical touch and those things in your home, that has been shown to have higher health ratings and lower risk of issues. And so when you get these foster kids in a safe and permanent situation, whether that be housing, school, things like that, it also improves their chance for healthy development and improved health, and it improves their school performance, and it decreases behavioral problems. So just think about that when you think about some of the kids in their situations. The more they can be moved to a permanent situation, the better. So just mental health conditions as a whole, as you can see with the age, there's kind of a bell-shaped curve almost, and then it kind of tapers and then it goes up again at end of life. So the youth between 10 and 20 are the ones that have the higher incidences of mental health disorders. This one in the orange. 1 in 5 children between 13 and 18 will have a serious mental illness. 20% of young people will receive services. So that is a serious discrepancy. That means we're missing the mark on a lot of the youth that are having issues. Fortunately, one of the things that happens when you are in a juvenile justice system or a foster system or a new school system is that you might get a triggered assessment. So some of these youth are picked up. But overall, prior to coming to care, some of the issues that they were having might not have been identified. There's a delay of 8 to 10 years between symptoms and intervention for some of these kids. And then approximately 50% of students 14 and older with a mental illness drop out of high school. So just think, the ones that aren't even having a behavioral health issue, or maybe they are, you know, those lower the chances of them having successful graduation and chances at occupational health. So why mental health matters for foster youth? About half of foster youth have clinically significant emotional or behavioral problems. And out-of-home placement is associated with disruption and attachment, and they're having a primary caregiver they associate with. So these youth are presenting with these problems for a reason. Often these problems, like I said, are neglected prior to, and they might have been dealing with violence and neglect in their home situation. And they're at increased risk of exposure to poverty, mistreatment, and again, that all impacts their mental health and emotional health, as well as their behavior. So what this means over time. So basically 50% of former foster children have mental health issues as adults, compared to 22% in a general population. And 30% of those suffer from PTSD as adults. So basically all of the trauma associated with their life experience, what they've been through, trying to adjust, impacts them long-term. So anything that can be done to help and support and stabilize in those earlier years, prevent some of these problems later on as adults. And that includes some of these, you know, being a lawyer and support at a tribunal hearing or in the school environment. So criminalizing mental illness. One of the reasons I went into the juvenile justice system is because I saw so many youth from foster or disadvantaged homes or underserved populations being criminalized. 2/3 of detention facilities lock up mentally ill youth because there's no place else for them to go. So either their parents have issues or their foster family has given up on them, or they can't get into a placement. So they go to the detention facilities. Every day, about 2,000 youth are incarcerated because there's no mental health services. So they go there pending an evaluation or pending a treatment plan. These are kids that should be in the community. They should be getting wraparound. But because of the lack of mental health services and resources, they're funneled into the juvenile justice system. In 33 states, juvenile detention centers hold youth with mental illness who either have not had charges against them of any kind or who have not been adjudicated of these charges. So they're allowed to be there without formal charges, pending either a mental illness evaluation or a transfer to somewhere for treatment. And again, jail is not treatment facility. Jail is jail. Juvenile justice detention centers are jails. So as you all know, as mostly lawyers, you know, these are the environments that they're exposed to because of their mental illness or because of the lack of services for the mental illness, whether they have behavioral problems or not. So they do have rights in the foster care system, however. So they have what we call the Medicaid early periodic screening. So that's what I was saying. They are entitled to certain screenings and evaluations to ensure that their health and needs are going to be met in the foster care system. I'm sure most of you have heard of the IDEA, Individuals with Disabilities in Education Act, where the IEPs and 504 plans are a part of that. So American with Disabilities Act for the 504 plans. And then there's the 14th Amendment where the substantive due process. So they are entitled to due process in the legal system. And as we've seen many times before, those rights are not always respected or given. So some of the disorders I've kind of thrown out there, but some of the common disorders of youth in foster care, and some of these you may have heard of and may not have heard of, or as lawyers, you might have reviewed a mental health assessment and seen some of these things, but trauma disorders, so like I said, PTSD, or adjustment disorders, meaning they're going through something in their life that's a big change or dramatic, and they're reacting to it. Anxiety disorders, and depressive and bipolar disorders. Needless to say, of course, our population does have a higher incidence of bipolar disorder, but some of these youth are being given these disorders or told they have these disorders based on a snapshot of their lives or a little piece of their life that they're basing symptoms on. So the diagnosis they receive may not be representative of what they have looked like in the past or what they will look like in the future, but they've got to go with what they're seeing now. So you will see more major depression, bipolar disorder, and other mood disorders. And if anyone has any questions, please let me know. Stop me, chat me, like she said. So some other common disorders are the disruptive impulse and conduct disorders. So these are what you all are going to see a lot in the school tribunal issues and within the legal juvenile justice system. So that can be ODD, oppositional defiant, intermittent explosive, and of course your conduct disorder, where they violate the rights of others. They might be aggressive, break the law, things like that. And then you have your neurodevelopmental disorders, your ADHD, autism, and learning disorders, where they're often undiagnosed, especially in the younger population. And of course, your alcohol and substance use disorders. Even though they are decriminalizing marijuana and some of the other substances, right now the laws still kind of aren't in favor for the youth, especially on probation, with them having access to substances. And some of them are having issues at school because of substances or being caught with substances or things like that. And lastly, your developmental delay, sleep disorders. A lot of them have issues with insomnia, sleep, nightmares, things like that, and your elimination disorders. So those are the kids who maybe in a stressful situation might resort back to urinating on themselves, defecating on themselves, and it might become an actual functional issue or impairment. So how mental issues may present. So in the school setting especially, they are with these kids for a long time and see a lot of symptoms, but also they don't necessarily have access to what is going on at home or what is going on in their environment. So they might see an anxious kid or worried kid, acting out or behavior problem kid, aggression, hypersexual, sad, lack of interest, and some of these other issues. And they might see that in the school environment, and they might have the support for them or not, depending on the school and the county. Here's some more, like I said, the urinating or stool issues, running away, lack of attachment, poor boundaries. So you can see these mental health issues and disorders might present and cause them to have some of the issues that you're dealing with, representing them in the legal or educational system. And they might not be getting treated or have not be treating effectively, or they might just not have the support or resources they need to have and carry out some of those treatment plans. And that could lead to a lot of the things that you all will see: suspensions, expulsions, multiple placements, detention, further neglect. So kids with mental health issues often are further abused because of their behavior or because of their problems. And that makes them a higher risk of having multiple abusers. And of course, the last one is over medication, which I see a lot, and I'll talk a little bit more about. So diagnosing. So these disorders are diagnosed by psychological and or psychiatric evaluation. And for those of you that don't know, psychological evaluation are the ones that are not medication related. So that is to look at emotional, behavioral, mental health from a perspective of emotions and not a medical perspective. Whereas psychiatric, like myself, we look from a medical and mental health perspective and say, could their seizure disorder be impacting it? Could their seizure medication be impacting it? Could they have, high blood pressure? Things like that. So those are the differences. And we are now using the DSM-5. That's our most recent guidance on diagnosing. And we always try to take into account a cultural background. And biopsychosocial, so this just means that we kind of try to look at the whole person, their biology, what they bring to the situation. A lot of youth in the system have parents with mental health issues, parents with substance issues, and that is genetically predisposed. So we take that into account when we're looking at their diagnosing and treatment plans, as well as their temperament and what they come into life with. As those of you who are parents or teachers, or no one kid is the same, right? So I have two boys, a 1 and a 2-year-old. Yes, pray for me. One, he's very social and fun, and jumps into situations and is very easygoing. And then I have another one who is more slow to warm. He checks it out. He looks at everybody, gives people the stink eye. So they just had two totally different temperaments right from the start. And that plays into account when you're looking at diagnosing and fitness models. So every situation isn't for every person. Every foster parent won't be for every child. And you have to take those things into consideration. Treatment modalities. So there are a number of different ways to treat disorders based on what they are and what symptoms are presenting. One is case management, where you help assess, plan, and implement strategies and coordinate their services. So you're really a support system and making sure people have what they need. As opposed to psychotherapy, where you're actually exploring their emotions, their behaviors, and seeking to improve their overall well-being from a therapeutic standpoint. So that is an actual treatment modality for them, for their disorder, as opposed to assessing and planning and coordinating. Parent management. A lot of the youth in the foster system require parent management. So that's the caregiver providing and bringing certain things to the table and helping them and implementing them and supporting them. And so they need training all on their own. Medication management, of course, you've heard of antidepressants, antipsychotics, mood stabilizers, sleeping medications. So those are all things you might see as a treatment for some of these disorders. And then you have a placement sort of treatment. So you might have a residential treatment where they go even before or after a legal adjudication or educational adjudication, detox if they have substance use issues, or an actual hospitalization if you feel like they're a danger to themselves or others and need immediate acute treatment. One thing that I don't think is talked about enough in this population and in systems of support, so you all as lawyers and supportive legal, paralegals in this environment, is resilience. So there's certain things that some kids or even adults can go through, and you think, how can you be okay, having gone through that? How are you sane? How are you functional? And there's other people who go through something a little less dramatic or a little less traumatic, and they're totally non-functional, and they're totally unable to pull themselves together or make their lives work. And that's a lot based on resilience. And that comes with what you, again, come to the table with, but some of that is taught and given, as parental figures or support systems, or even in the educational system. And it's a dynamic process, right? How you were at 10 or 12 might not necessarily be how you are at 20, 25. And you generally gain more resilience over time. But if you're repeatedly exposed to traumatic situations, it can impair your resilience over time. So with these type of kids and adolescents, there's always needs to be a team approach. And even you from the legal aspect, you can reach out to the treating provider or the psychologist or their caregiver to say, hey, let me find out as much about this kid as possible before I come up with a strategy or before I know how to represent them. You know, especially in these tribunals, you will see their psychiatric and psychological reports and say, hey, it says he's supposed to be on medicines. Has he been on those? You know, has the school done what they were supposed to do legally and what they were entitled to before going to a, you know, expulsion or a suspension or hearing? And they need those advocates because there's going to be a lot of people with some of these kids because they can tend to be difficult that just want to take the path of least resistance and say, hey, get them out of here. Or, you know, we don't want them in our class, or we just send them to the office, or we just send them home, when they are entitled to a healthy life, education, and resources, just like everyone else. And all the members play an important role. And information sharing is key because you don't know what you don't know. So you have to look into it and ask others to fill in the gaps where you have them. Lastly, you know, all perspectives and voices need to be heard. So, you know, their caregivers, you know, they do see them in a different environment. So that information is relevant. The teachers, the principals, all of those perspectives need to be heard because a youth isn't the same, you know, in all situations. You know, people tell me, oh, your kids are so good, they're angels. And I'm like, what? They're terrible at home. Like, what are you talking about? Are these the same kids? It's the same thing with some of these youth. They're going to present differently. They're going to have some people that, you know, want to support them and aid in their resilience. And you're going to have others that are generally bothered by them, or they can't figure them out, or they don't understand them, and their perspective is totally different. And then we always have to be culturally aware and responsive to the child and their family and what they're going through within these systems. And with that, I will end. And are there any questions? Anything I went over too quickly? I know I kind of sped through.
If you have a question, you can post it in the chat, or you can put it in the Q&A.
Oh, let me pull my chat. Where is my chat?
It's going to be at the top part of your screen.
Okay, and I'm going to stop sharing so that you can see my face. Okay, here we go. All right, so it says, I'm not seeing any questions in the chat. Are you all seeing any questions in the chat?
That they might have sent them to you directly, but we don't see them.
All right, I'm not seeing any in the chat. Are there?
The whole time, so if people have questions during that you want to jump in and answer, are you willing to stay with us for the afternoon and talk it through, or not?
I actually can't stay all afternoon, but if you all send me your questions, I can respond to them. I can type them out, or I can maybe hop on a follow-up call or something like that if it comes up, for sure.
Fantastic. Well, thank you so much.
All right. Thank you all for having me, and definitely thank you for being interested in helping these youth.
And it is the youth. And so we start with the youth. And Dr. Ayo is the start of what is a great afternoon. As we dive now into more of the looking at the youth, where you're going to hear from Kamara Guidry, who is an Equal Justice Works Fellow with Georgia Appleseed. And we also have two other, or a handful of other panelists. We've got 3 members of the Young Professionals Council who have done tribunals. They have trained for a long time, and they're going to walk you through that process. For now, we're going to dive into the issues of special education. Again, focusing on the child, because That is what this is all about. So let's get this rolling. All right.
All right, thank you, Caroline. And I just want to say thank you to Dr. Ayo one more time. And I really appreciate you grounding us in the need to see our entire client. I think it feeds right into what I'm going to be talking about as it relates to students or clients with disabilities. So we appreciate that. We appreciate the information you gave us and just pushing us to consider the whole child when providing representation. And so this portion of the training, we will be looking at, in the event your client has special education services that they receive at school or they have disabilities. Next slide, Caroline. Dr. Ayo talked a lot about our clients may have other disorders, they may have disabilities. And so we want to make sure that you have the information on what protections are in place for them when they do have disabilities. Looks like we lost the slideshow. Hold on one second, y'all. All right, so as she's pulling that up, I'm gonna just go ahead and jump right in. So there are protections for students who are receiving special education services or students who have disabilities. Dr. Ayo mentioned it briefly. You have the IDEA, Individuals with Disabilities Education Act, as well as Section 504 of the ADA. And so what that means is before a child that has a disability can be removed from their school for 10 days, 10 cumulative days, there must be a manifestation determination review. Next slide, Caroline. And so with the manifestation determination review, what the child's IEP team or school team is looking to determine is whether or not the alleged conduct that they are being suspended for or expelled for was a manifestation of their disability, or whether the school failed to properly implement their IEP. And so the MDR must occur within 10 days of the violation. And that's to ensure that a child is not being pushed out of school for behavior that is a result of their disability. Next slide. And so there are two results that can come out of an MDR. It can be found that the behavior is a manifestation of the child's disability, or it's a result of the school not properly implementing the child's IEP. And in that case, the child cannot be suspended. You wouldn't go forward with the tribunal. And the IEP would need to be amended, because what that says is that the IEP is not meeting the child's needs. It's not working, essentially. And then the other potential outcome is that the behavior is not a manifestation of the child's disability. So when reviewing the child's records, reviewing their IEP, talking to the school psychologist, talking to the parent, if they come to the conclusion that the alleged behavior is not a result of the child's disability, then the school would be able to move forward with the suspension or expulsion. And that's when we get to the tribunal. And so when you think about the MDR, I think Dr. Ayo's presentation really set us up for thinking big picture. When looking at the MDR, you're looking at the whole child. You're looking at the IEP, and in the IEP, you're looking at what disability does the child have? What support should they be receiving? What's their disciplinary history? Is this the first time that they've had this particular disciplinary concern? You're looking at their records with their therapist, their records with their psychologist. You're essentially getting a full picture of the child to determine whether or not the alleged conduct is a result of their disability. Next slide. And I know Caroline said that we're going to have many more trainings, and one of them is a full preparation of getting ready for MDRs. But just to kind of give you a precursor to that,
You see that Kamara has frozen, so we're going to hope that we'll give her just a second to bring her back in and go forward. Again, as this is going forward, if you have questions, please let us know.
Hi, everybody. This is Rachel. While we're waiting for her to jump back in, I want to just say two things, if that's okay, Caroline, about the manifestations.
Absolutely.
Okay. So while we're waiting for her to come back in, I want to talk about a couple of things. The first is our project is representing students at the tribunals. The manifestation determination is a separate meeting and thing that is going on at the time of the tribunal. But if your student has an IEP, they have to do this. So it's something to be aware of because these can be hugely important. One of the things that she just said on the previous slide is that if it is found to be a manifestation, that means that the student cannot be suspended. That means no further discipline action can be taken. That is so huge for a lot of these children, right? If it is found to be a manifestation, then you cannot suspend them or expel them. So these can be very important. We don't necessarily ask you to go with the students to these, but if you're able to, or you know this is going on, we do this for an issue spotting so that you can be aware that this is going on, because if it is something that is tied to their disability, no further discipline action can be taken, which is just so huge. Okay, so it looks like she's rejoined, although I'm not sure. KG, are you there? No.
Yeah, I'm here.
Okay, good. I'll turn it back over to you. I just wanted to say those couple of things while we were waiting for you.
Yeah, thank you, Rachel. And thanks for stressing the importance of the manifestation determination review. It looks like you got us to the end of it. I just wanted to emphasize that at the end of the day, this is an opportunity for us to block it from going to a tribunal. This can have a huge impact on whether or not the child even has to face the situation of being forced to leave their school or being pushed out of their school community. And so it's just as important to prepare for the MDR as it is to prepare for the tribunal, which we're going to hear a little bit from Stan right now about preparing before the tribunal.
Thanks, KG. Hi, everybody. I'm Stan Hill. I'm a member of the Young Professionals Council. Not as young as I used to be, but I still enjoy being considered among young people from time to time. In any event, I'm here to talk about some of the items you should be thinking about when preparing for a tribunal. And at the outset, I will preface this by saying, just by participating and taking a case, you really have already won for your client and for our program, because the alternative in many instances historically has been that these students are going to tribunal hearings without any representation at all, which is kind of hard to believe when you consider that they're facing expulsion or a long-term suspension from school. And they aren't trained lawyers, and they may or may not have experience with a tribunal, but they would be facing adults laying out charges against them, presenting evidence, making arguments to a hearing officer, and they're all alone. And your presence alone makes a world of difference, and your skills as a lawyer make a world of difference as well. And so as we go through this today, I think it's important to keep all that in mind, because while this may not be what we do every day as lawyers in our own practices, it may dovetail with what we do to some extent, it may not, but your presence means a significant amount, and and as you'll see through here, there's a lot of things that you can do as a lawyer to really have an impact on the outcome. And we're not necessarily looking for Perry Mason moments of exoneration, but rather, effective representation and allowing the student's story to be heard, and let the decision makers make the decisions they'll make. But there's a few things you can do, as you're getting ready for the tribunal to set yourself up for, potentially having some success and defining what success might be. And ultimately, again, just the representation really means the world to our program and to the child. And so where to start? Start at the beginning, of course, with who is your client. And It may seem obvious, of course, your client is the child, and there may be individuals around the child who would like to be involved and would like to be kept in the loop about what's going on, of course, foster parents and caseworkers among them. But it's important, as a lawyer to maintain the attorney-client privilege where it makes sense to do so, and especially if the student is facing or potentially could face criminal charges associated with the alleged misconduct. So whether that might be fighting or possession of a illegal substance or what have you, you want to keep in the back of your mind that there's the potential, what potential for criminal charges there might be. And certainly if there already are charges pending, that is going to impact your strategies for the tribunal hearing itself. And may also help to inform what kind of investigation you can and should be doing leading up to the tribunal with the very limited time that you might have to prepare. And we'll talk a little bit about that in the coming slides and things you can think about as far as getting extensions of time. And when it comes to setting goals and expectations for your client, that's huge. I mean, that's one of the lawyer's most important things to do, no matter what kind of law you're practicing and what you're doing. And obviously, it's great to keep kids in school, and that is the number one objective. Sometimes that's not possible, but there's some creative ways of trying to get there, or at least minimize the time the student is out of school so that they're in school more than they otherwise would be. And of course, to provide representation so your child can be heard and to have effective representation and ensure that they get the due process hearing that they're entitled to get when facing a suspension of 10 or more days. We can go to the next slide. So, in furtherance of our goal of keeping kids in school, there are going to be some opportunities along the way for some creative solutions to achieve that objective. And here are some of the examples listed in the slide. They're terms that you may or may not be familiar with, but a restorative justice circle, behavioral contract, an in-school suspension, or a time served suspension. The best way of approaching this, I found, is to keep asking questions throughout the process, especially as you're talking to the school board attorney or other people that are on representing the school board that are willing to talk to you, to find out what's possible and what might be something that's workable for your client's situation. One thing to keep in mind, I mean, especially if you're a civil litigator, most clients tend to want to avoid the risks and the distractions and the costs of time and money of having a hearing. And so as an advocate for your student, you may be thinking that, and rightly so, that avoiding a hearing has value to a school board. And so there's opportunities along the way to discuss potential resolution short of a hearing. And when you have those opportunities, that's something where some of these options can be brought to the table. So it's something to be thinking about, and along the way, explaining that to the student and setting the expectations early in advance about what your role is as their advocate to ensure that they get due process, to make arguments on their behalf where it's appropriate, and that you're not there to exonerate them at all costs. And that is not necessarily your objective, nor is that possible or feasible in many cases. But it is important too to explain the potential consequences and and explore what the students ultimately what's possible for them, and communicate along the way, of course. We can go to the next slide. Well, it wouldn't be a legal CLE without a little bit of case law and discussions of cases. And so here, the leading watershed case is the United States Supreme Court case of Goss v. Lopez, which set out the standard for due process that applies here, which is that the student will have due process rights of notice and a hearing when facing a potential suspension of more than 10 days or a potential expulsion. There's also a statute in the Georgia law, the Georgia Fair Tribunal Act, that lays out the due process requirements, and you see them there on the slide. And how those due process requirements are initially presented, or how they're initially fulfilled, is through a notice that is supposed to be sent to the student's parent or guardian in advance of the hearing. And what we found over the years, and I think Rachel can explain some of her experiences later with this in her part of the presentation, is that defects in the notice are common. And you may be surprised to hear what some kinds of the defects are in the notice, but a defect in the notice can potentially invalidate the entire proceeding because it's sort of the bedrock or the cornerstone upon which the due process rights are based. And so when you are investigating the student's incident and ultimately getting ready for the hearing, one of the things to definitely spend some time on is looking at the notice, studying it closely. Does it state its time and the place of the hearing? Does it have a short and plain statement of the charges against the student? And specifically, does it include references to the particular code of conduct provision that the student is being accused of violating? One thing that cannot happen is the school board can't change tunes in the middle of the dance by saying, oh, well, it was not code of conduct rule number 6, it was instead code of conduct rule number 7. They can't do that. They have to stick to what's in the notice. So it's important to make sure that that issue is the only issue that is brought forward in the hearing, and to be familiar with the other parts of the code of conduct so that if you see that they're trying to change their tune, that you'll be ready to step in and make that objection on the record of the hearing. And then, of course, sorry, you go back just a second. And then a statement regarding the student's right to present evidence and to be represented by an attorney. And that's where you come in. And like I said before, if it weren't for you taking the cases, it's quite possible the student would be going to this proceeding alone, and we would not want that to happen. And so that's why it's really, we're really excited that you all are here today, and hopefully that you'll be able and willing to take cases when they come along in the future. Now we can go ahead. So as I mentioned, that student code of conduct is quite an important document. Most of the school boards will have a website where the code of conduct can be downloaded. And so if you don't already have it, you can get it there quickly. And if not, to contact the school board, school board's attorney, I should say, and get it from them. And so now talking a little bit about some of the fact investigation you might do as you're getting ready for the hearing. And again, you may only have a few days to do this, and that's just the way the process works. And of course, there's only so much you can do in a few days. So we're trying to highlight some of the sort of the high value targets or high value exercises in preparation. And of course, if you had infinite time and infinite resources, there's a lot of things you potentially could do with the situation, but these are the exercises we find have the greatest value for the time that you can prepare. Of course, talking to the student will have a story to tell, and keeping it privileged again to the extent you possibly can, especially if there could potentially be criminal charges pending, to get an understanding from the student's perspective of what happened. Who are the other witnesses? What was the involvement of other people? And not just at the incident, but what happened after the incident? Was the student taken to a room, forced to write a statement or sign a statement, sign a confession even? We find that sometimes there will be signed confessions from students. Were others made to write statements to the student's knowledge? What has the student heard since the incident about what's to happen or who may be involved? All good questions to ask. And then talking to the school board attorney as well to see what their position is on the matter, whether you're initially raising the call in the context of exploring a settlement, or to just get information first and then get back in touch with the school board attorney about some suggestions for how it could be resolved in a productive way, and requesting documents from the school board about the incident. And that can be anything from any statements that were signed, the student's school records, the IEP if you don't already have it. And even if you aren't going to be representing the student at the manifestation determination, you still would like to get your hands on the IEP so that you can build that into your advocacy on behalf of the student to help tell their story. We'll talk a little bit more about that, and you'll see how that would unfold as the hearing, with the hearing itself. And then of course, any statement that the student has signed, they may or may not have, they will not have been given Miranda rights in the context of school statements, but nevertheless, you want to get your hands on those statements, and the school board will use them in the tribunal hearing, and you can expect that they will, but you still want to have them to see what they'll say. And then of course, thinking about other witnesses, who could you talk to? Who would be able to come to the hearing? And we'll talk a little bit about subpoenas in a little bit, but just getting the facts. And then of course, talking to people
that know about the student outside of school, or that know about the student inside of school and have good things to say about the student. That can be helpful as well. Outside of school in particular is most effective because, as you'll see, and we'll talk a little bit about this, teachers at the school and the staff members at the school will ultimately, at the end of the day, be loyal to the school, not to your client. And so while they may be able to give you information in a one-on-one conversation, it's less likely that information would hold up if they were brought into a hearing to testify with the school principal present or with other school board members or influential school leaders present. So folks like Boys and Girls Club counselors, clergymen, church leaders, other folks in the community who might have something to say about the student, that can be impactful just to get that information, and then you can consider whether they would be good witnesses at the hearing for any purpose. One other thing about the investigation, we talked a little bit about the MDR before, but it is possible that the MDR has not occurred by the time you're getting involved, or the school board sees fit to do the tribunal hearing before the MDR occurs. In which case, I'm sure Rachel would weigh in a little bit about this as well. I know she's had some personal experience with this and the sequencing of those two events. It's sort of a chicken and egg kind of thing. At least that's how some people see it. But you know, that's something to think about as far as the MDR hasn't occurred yet, how much you want to raise that in the tribunal itself.
Yeah, let's take a second and talk about that now, Stan, if you want.
Sure.
So different school districts do this different ways, and that is because of the school of thought on this. So one of the things is that a lot of school districts do the MDR before the tribunal because, as we said, if it is found to be a manifestation, then no further discipline can be had, so there's no point in doing the tribunal. However, one of the problems is that in order to do the manifestation, you have to kind of presuppose that the child has done what they are being accused of doing, right? So some school districts believe, well, we have to do the tribunal first to find out if the child is guilty or not guilty, have they done it or not done it, before we can have the MDR, because if the student is disputing what they did, then how can we kind of have this meeting when we don't really have a determination of what really happened? So there are certainly all of those kind of schools of thought on it. I also, years ago in Cobb County, had a case where it was found to be a manifestation and they still wanted to do the tribunal because it was important to them to try to get the guilty finding that the child had done it so that it went on his record, even though no further discipline action could be taken. I went rounds and rounds with the school district attorney, and that's what ended up happening. So, you know, some of this is just kind of finessing this. And if you don't know, which you may not know, and we may not know if it's an unusual county or not one of kind of the metro counties that we deal with, just ask. Nothing wrong with asking about kind of how this is going to go and some of those questions. Also, one of the things to point out with DFACS is that, we are kind of statewide now in that we get referrals from all over, but students can be placed anywhere. So they can be kind of under, let's say, the Fulton County purview, but be placed in a county outside of Fulton County. So Fulton County DFACS may be running the show, but they could be placed in Rockdale County or something like that. So sometimes the counties are just we don't know these questions. So those are things to ask and to figure out so that you know kind of what's going on.
Yeah. Thanks, Rachel. So a few other strategy considerations to keep in mind as you're preparing for the hearing. Depending upon how much time you're given to prepare, you might consider asking for an extension of the hearing. There's pros and cons associated with that. The major drawback is the student will stay out of school until the hearing happens, more than likely. And if our main objective is to bring the student back and keep the student in school, then it may be that you're better off pressing forward under a tight deadline than trying to extend things out to have more time to prepare. And it's one of those things that you naturally want to talk with your client about, but also that recognizing based on your initial assessment of the facts, if things aren't likely to improve materially with more time, that you're better off just going forward or getting into a negotiation posture as quickly as you can, and then perhaps using the time pressure of the hearing in your favor to negotiate a resolution with the school board without having to go through the hearing. is your student's right to have the hearing within the 10-day period. And so ultimately, you can potentially leverage that for your advantage. And then, ultimately, when you're plotting out your hearing preparation, you have to make decisions about who ultimately will testify at the hearing and in what phases of the hearing. So you can think of the hearing as being bifurcated to a liability and a penalty phase or punishment phase. And some school boards may not have the same procedures, but it doesn't, again, as Rachel said, it doesn't hurt to ask. Just simply ask the school board attorney, I'm expecting this to be this way, or ask the hearing officer on the day of to confirm how it is going to be. And if your student's liability or guilt in the matter is either something you can't effectively contest or dispute, or it's something that you, for strategic reasons, wish not to dispute because of the pending criminal charges and the fact the hearing will be recorded and anything the student says at the hearing could be used against them in a criminal proceeding with higher stakes, that you may simply have nothing to add to that phase and wish to save your arguments for the penalty or punishment phase of the hearing. So those are things to be thinking about. And you can have witnesses testify on behalf of the student in simply just that second phase of the hearing if you're not going to contest the liability piece. And so one thing to think about with any witness, whether it's in the liability or the penalty phase, is that they will be subject to potentially cross-examination by the school board attorney. And you want to prepare your witnesses for that possibility and keep your direct questioning in mind, given the fact that there will be cross-examination more than likely, especially if the student is to testify. And so spending time preparing, especially the student, if the student's going to testify, and any parent or any other witness, is time well spent in advance of the hearing. As far as the second phase, the penalty or the punishment phase of it, having the student read a statement that they wrote in their own words can be an effective strategy. Of course, if there are pending criminal charges or potentially pending criminal charges, that may not be effective. You don't want the student to necessarily admit to guilt or for something that that is in doubt in the criminal system. But having the student write something in their own words can be effective, and something that you can have on the ready if you need to for that part of the proceeding. You can go ahead to the next slide.
Quick question though, Stan, can you tell folks in the room how they might know to look for? What are the telltale signs that it might be a criminal case?
Well, I think that, I am not a criminal lawyer, but in my experience and just sort of seeing the cases over the years, anything involving drugs, anything involving weapons, physical assault, things that you would consider to be serious crimes or have the ring of a serious crime to it, would be things that I'd be most concerned about. If it's a school fight that didn't result in serious bodily injury from what you can tell, or was just pushing or shoving, or just disrespectful words, swearing, things like that, of course, then that's not going to be something that's going to be a criminal matter. But there are some gray areas there, and again, that's where just investigating a little bit and then making a decision and putting it to the student as well that look, it's possible that there are criminal charges that could be brought on this. If you say something could be used against you, what do you I would recommend this. What do you think? And then if the student wants their foster parent to weigh in or their caseworker weigh in or whoever they'd like to have weigh in, you can think about how to present that information to them as well, so that they can weigh in for the student's perspective. I mentioned a little bit about this, but I'll just briefly touch on some of the finer points now. If there's any witness that is an employee of the school district, a teacher, a staff member, a counselor at the school, they may be helpful to you in a phone call. They may not be, but even if they are helpful to you in a phone call or in an informal setting of some kind, you should expect that they're not going to be as helpful to you in the hearing itself, simply because they have a job to protect. They're an employee of the school board, and right, wrong, or indifferent, that's going to weigh on how they present. And while you may subpoena them or subpoena anybody, the school board must issue the subpoena. There is no enforcement mechanism. So ultimately, whether someone comes to testify is a voluntary exercise, And, so you should set your expectations accordingly about that. Especially if they're a hostile witness, it may be that they're not, they have no reason to show up, and the school board has no reason to try to get them to show up either. And as I've mentioned, thinking about opportunities to talk settlement or talk about a framework for settlement or a framework for resolving the matter, so that the student can, have appropriate punishment for whatever the school board is saying if you're not contesting it, and get the student back into school or in the school setting with some restrictions such as an in-school suspension. That is something that is definitely worth exploring in advance of the hearing. And I believe yes, I think now we are on to the hearing itself, and over to Rachel and Craig, I believe. Or is this still me?
No, this is us, I think.
Okay.
All right, here we go. All right, thanks, Stan, for walking us through all that. So Rachel and I will take you to the next step here on how to handle the hearing. And I think overall, before we kind of jump into it, I think the first thing is, we'll try to bring you some practical advice today, practical thoughts on how to handle these. I guess first of all, don't be afraid to take one. I think that's an important consideration for everybody, regardless of your level of experience, regardless of your level of experience in litigation. So even if you're a corporate lawyer who's interested in getting involved, if you're a junior associate at a law firm, you can do this. And what works even better for us, it's a short time commitment. I know Stan talked about this, but there's a short turnaround time between when obviously students get the notice and when our DFACS partners get the notice about these hearings and when they take place. Do not be intimidated by the fact that you may only have a few days to get ready for this. That's fine. You can do it. We can certainly offer help as needed and advice and guidance on how to jump in and do these. So don't be intimidated by the fact that you only have a few days. And in fact, I think that makes it a really great program for lots of attorneys, lots of junior attorneys, because if you have a couple of days that you can devote to it, because your schedule happens to freeze up. You'll take the case. It'll be 4 days later. It'll be done, and then your commitment to us is finished. And always think about what the other result would be, is if there's no lawyer there, there's nobody there to represent this kid in foster care at the hearing. Like Stan said, your presence alone will just make a huge difference in the potential outcome here. Whether you litigate it all the way through the hearing, whether you come to some settlement on it, your presence, just having a lawyer there, does make a huge difference in outcomes. We've studied it, we've looked at it, we've looked at data on this, on hearings, where we don't get an attorney there versus where we do. The results are just, much better. So again, we just want to be, practical, thoughtful, and yeah, take a case. You'll make a very big difference in the life of a kid who Dr. Ayo was talking about, really needs it and may have never had anyone like this, stick up for them or help them or or advocate on their behalf. So anyway, anything else to add on that, Rachel?
Yeah, I just want to echo that. One of the ways that we measure success of the program is simply placing a case with a lawyer. We have a lot of anecdotal data, as Craig has said, of good outcomes when we have a lawyer. Your skill set is that you are a lawyer. That's all you need, right? We are doing our best to train you. You have the manual. We are at your disposal if you need help, but you're an advocate. You're a lawyer. You're somebody in the room that can go to bat for this kid. And that is how we measure success of the program. Because this brings me to my first point. oftentimes the children have done what they are being accused of doing, right? We are going to do our best to give you the practical tips and advice on how you do these tribunals, but the practical information that you need to know is that these can be really tough to win. And often the kids have done it. By the time they're being brought up for tribunal, they've probably done it. Depending on what it is going to determine on some level what the sentence, so to speak, is going to be. But these are very difficult to win, and they're very, very difficult to win on the grounds that your kid did not do what they're being accused of doing, right? So we don't measure outcomes on that basis, right? But there are lots of great results that you can get by just showing up, by settling the case, by being an advocate, reducing the punishment. We're going to focus a lot here today on the punishment phase, mitigating the punishment, because that's where you can do the best, the most good, the best job at trying to get a good outcome for these kiddos. Because in the guilt phase, this is kind of, so often the hearings are bifurcated, right? Where we do the guilt phase, where we determine, did the child do it? And then the other thing is, okay, they did. So what is going to be the punishment phase? Whether or not it's formally bifurcated or not, every county does this differently. You can ask if you don't know. It's okay not to know. Some of us know the different counties and what they do, but some don't. But at the end of the day, we're going to kind of think about it in a bifurcated manner, even if it's not truly bifurcated. So the guilt phase is, has the child done what they are being accused of doing, right? Did the child violate the code of conduct, the policy, the portion of the code of conduct that they are being accused of doing? And often you may not have a lot to present at this time, right? The school district is possibly going to present their evidence, and you may not have a lot to say. The punishment phase is where we're going to determine the punishment. And our goal and our hope is to keep these children in school, in their regular education environment. There is often the option to go to an alternative school. Those places are generally not great, and transportation is not provided. So one of the problems that we run into and why this project is so important is if a child is kicked out of their school, their home school, often that comes with a change of placement because the foster parent either A, can't get them to alternative school or doesn't want them at home instead of going to school. So that necessitates a change of placement. So the punishment phase and focusing really hard on why this child should stay in their current placement and not be bounced around is going to be hugely important, right? And that's one of the big things that we focus on is keeping the kids in their current regular education schools and making sure that the punishment fits the crime, so to speak. And as I said, the districts do not always officially bifurcate the hearings. We kind of talk about it in that manner, but at times they do. So these are the questions kind of you'll just need to ask if you're not sure when you take a case, if it's a county that we're not as familiar with. Okay. All right, so the school district goes first. So they present their evidence first, and they have the burden to demonstrate that the student has violated one of the school's policies. The code of conduct provision that they have cited in their notice is the one that they have to be presenting that the student has violated that provision. And they go first and present their evidence first that they have on what it is that the student has done. Their witnesses, whether that's teachers or students, or if they have written statements, whatever they have, the school district is going to present their evidence first on what happened and what the child is being accused of doing. And as I just said, the evidence may be documents, witness testimony, and all of that. Now, you as the school district's lawyer, you as the student's lawyer has the right to cross-examine the witnesses. You can ask them questions, you can object to documents, you can object to testimony, and all of that. So one of the things you can do on the cross-examination of the witnesses is kind of what is it that you are, do you have cross questions? Did they see it? Oftentimes the principal will testify and say, I heard this happened. You know, did you see this? Did you investigate this? You know, did anybody see this happen? Is there any kind of camera testimony on this happening? Are the statements hearsay statements? Are they presenting a bunch of student witness statements and the students are not there? So you have the right to object to these documents that are being presented and to cross-examine witnesses. It's okay if you don't have any questions on cross-examination, okay? One of the things of being a trial lawyer is kind of, there's this guy that presents cross-examination. He's from like the 70s. I don't know, but I will never forget. And it's like 10 things that he does for cross-examination. And one of them is kind of like, know when to sit down, right? Know when you're done. Know when to not, it's okay. During the guilt phase, if somebody is saying, I saw this child do this, okay, well then there you go. You may not have any questions during this phase. You may have questions for that person during the punishment phase. But when the person is saying, I saw this kid do this, and your kid has said, oh yeah, no, I did it, maybe you don't have any questions, and that's okay. Kind of, it's like know when to hold them, know when to fold them, right? It's okay if you don't have anything to say. Be brief and sit down and just move on, and that's okay, because part of it is getting to the punishment phase, right? So that's kind of what there are times that you're going to have a lot of good cross-examination questions, and that maybe they're not presenting a great case, or it is all hearsay, or it's the principal saying, oh, so-and-so told me about this, but no, I didn't see it, or whatever the case may be. But if you have a good witness, it's okay that you don't have cross questions.
Rachel, can you also just, I guess, paint the picture? So when you come into one of these hearings and you have the cross-examination, you have the evidence, I guess, who's there and who's in the room? What are their different roles? And who are they working for?
That's a great point. So the hearing officer is supposed to be a neutral hearing officer, okay? Sometimes it's one hearing officer and sometimes it's a panel. In Cherokee, I know they do a panel of 3. Fulton, I believe, is just one hearing officer. They're supposed to be neutral. They are hired and paid by the school district, but they're supposed to be neutral. Depending on kind of the school district setup, it kind of depends on how it works. In Cherokee, you sit at kind of like a square connected table. So the hearing officers sit on one side of the table. You sit across from them as the kind of parent attorney next to the school district's attorney, and extra witnesses kind of go around the table. In in Rockdale, I did one, and it looks more like a courtroom. The hearing officer is one hearing officer, sits up front, kind of up high, and then you have counsel tables where you would sit at your respective counsel table, and then you have kind of the gallery behind you if there are witnesses or observers. Now, everything I'm saying is pre-COVID, okay? I actually have no idea what they would do if they did this in person during COVID or post-COVID or any of that. As in my practice, we are doing, I do family law, and so we're doing everything virtually. So they very well can do these virtually if that's what they choose to do. Or certainly the Cherokee method of sitting around the table does not feel very COVID appropriate or friendly. So I'm not sure that that's the way it would be. But in terms of painting you the picture, it can look more like a courtroom, like your traditional courtroom, or it can be a little bit more informal in terms of a table setting. They probably won't wear robes or anything like that. When it's a panel in Cherokee, typically they use like retired principals and things like that. In Fulton, it can be those, but it's a little bit more training on a hearing officer type of thing. But then you have the school district's lawyer and their witnesses, typically the principal sitting with the school district's lawyer, and you would have your client who is the child and probably maybe the foster parent or the DFACS worker sitting with you, and then any witnesses or anything like that. You can sequester witnesses, right? Ask that they not be in the room during testimony. That's commonplace. That's not a big deal. But you would ask for all witnesses to be outside of the room until it's their turn to testify. And again, some of this and a lot of these are reading the room. And kind of, not being overly aggressive or making sure that you are kind of appropriately making your objections or sitting where you need to sit or handling this the way you are, but reading the room in terms of how aggressive or zealous do you need to be? So part of when we do this, we like to give war stories. It hopefully makes it a little bit more interesting for y'all. So I'm going to give you two examples of this just kind of while I'm talking now. In Cherokee, as I've referenced, they have this panel. And I was there with a student, and we will get to this later, but at the end of it, this was not a foster care child, but the child read a statement and his dad read a statement that I had helped his dad. His dad wrote it. It was phenomenal. His dad read it at the end. And then I said, okay, thank you. I'd like to make a closing argument. And the panelists said no. And they just said to me, no, we don't need to hear from you. And I said, thank you. I appreciate that. But as the lawyer, I just kind of want to wrap this up. And they said, no, we're not, thank you. We're not going to hear from you. And they said, you know, the dad just gave a great statement. There's nothing that you can say that's going to be better than what the dad said. So no, we're not going to hear from you. And I said, okay, I understand that. I said, I just want to note for the record that, you know, I've asked to make a closing argument, and I'm going to waive that at your kind of behest, right? I was pissed. That's it. I was not happy, right? My client wants me there. I had some things I wanted to say that the dad did not say. He made this impassioned plea on behalf of his child. But reading the room, there was stop talking, right? Like I just needed to stop talking and be done with it and all of that. Also in Cherokee, you don't stand when you talk because you all sit around the table. Whereas in Rockdale, it was more of a courtroom. So I felt uncomfortable and stood when I was talking, as did the opposing attorney. Now, when I did in Rockdale, the impartial hearing officer at one point testified during the hearing. At one point during the hearing, there was a question of something and I objected, and the hearing officer said, well, I know about that, and I'm the only one in the room that knows about that, so I can testify to it. And I said, well, with all respect, Your Honor, you're supposed to be the neutral hearing officer. I don't really think that you should be able to testify at this. And he said, well, I'm the only one in the room that knows about it, so I'm going to testify. Okay, read the room. I was clearly a bit put off and shocked and kind of stumbled over myself and kind of said, okay, Your Honor, I just kind of object for the record that you know, I'm not sure that your testifying is appropriate. But then he's going to say whatever he's going to say, right? And you got to be respectful. You have to do this. This can be a little bit more like a loose type of courtroom, a loose evidentiary standard on all of this. And so reading the room and making your objections respectfully for the record, and then they're going to do whatever they're going to do. So hopefully that gives you some examples of kind of when things go a bit awry and how you handle it. Not that I'm saying I handled it well, but just kind of reading the room. Okay, I think next slide. Okay, right. So these are important points. Craig, do you want to cover these?
Sure. So a couple of things. I guess even before we get to that, I guess one of these, preliminary thoughts, you know, on the evidence that comes in, or the school district's evidence. Does the school district have to provide you or provide us with the records that they're relying on? Do they have to give us advance notice of the witnesses that are going to speak, or is it just may have to kind of deal with it on the fly?
I'm sorry. Can you repeat that?
Sure.
I apologize.
Sorry. I guess the question was, one question we had was, does the school have to provide their documents and records that they're going to rely upon in advance? And do they have to give notice in advance of the witnesses that they're going to have testify?
Whether or not they have to, but they should. Often that's in the letter, but typically when you talk to the opposing counsel, the school district's lawyer, you can get that information, but they should give you that information. The documents that they're going to rely on and the witnesses. There's not much to do if they don't, but typically they will. There is a panelist, not a panelist, there is a comment that says in APS they will not do that. You know, so again, it's trying to get it. Again, they should. If they don't, there's not a ton that you can do about it. But in Cherokee they do, and Fulton I believe they do. So again, it's really just kind of trying to get at the most information that you can. So yes, they should, but again, they may not. But the things that you can typically expect that they're going to put into evidence is the student's discipline tracker. You can put in the student's discipline tracker. They will typically do that. Grades. If there are any statements, you want to ask your student if they have put down, if they wrote any statements. Do they know if other students wrote statements? So those are kind of the typical things that they may do. If there's a recording, where did this happen? If it happened on the bus, is there a bus camera? Things like that. So, you can get some of that intel from your student, and then some of this is going to be just stuff that you kind of we know kind of comes into play, but they may not provide it. And there's a question I want to answer quickly as well. There was a question that said, if there is a 3-person panel, does guilt require a majority or a unanimous verdict? I don't know how to say that word. Sorry. They deliberate in private. It's going to be presented as a unanimous decision. I think it's just going to be presented as a unanimous decision. This is our decision. These are our findings. So probably, I guess the answer to that is technically it requires a majority, but there's no way that you're going to know if it was 2 to 1, or 3 to 0 or something like that, because they're just going to typically one of the panelists does the talking and presents you with the finding, and it's just going to say that. But they're typically pretty aligned with each other. Okay.
Great. Thanks, Rachel. Yeah, so moving onto this slide, how you're going to handle it, how you're going to conduct yourself, how is it going to go during the questioning, and the questioning by the lawyers for the school district. And so objections are usually overruled, but that does not mean, I think, that you shouldn't make them. So what's important is you don't want to be overbearing, you don't want to go nuts, you don't want to make a scene, but you definitely want to raise those objections to preserve that right, to preserve those arguments for potential appeal. And at the end of this later today, I'll very quickly run through the appeal process, but just know that there is an appeal process, and you want to be able to preserve those objections, preserve those arguments, particularly to the more egregious situations, things that you really feel that are really prejudicing your client, or in Rachel's example, having the hearing officer testify about, get himself sworn in so he can offer testimony. It's those kind of things that you want to be aware of, and don't be afraid to make those objections, even if the documents are going to be allowed into evidence or considered. In some ways, becomes a little bit more like an arbitration or a non-jury trial. There's not going to be those concerns about jury confusion or prejudice in the jury, but if the trier of fact can certainly take the position that he or she will appropriately weigh any particular evidence that comes in, including hearsay evidence. It can be that can be allowed, typically would be allowed, but as we see in the comments, it's not necessarily, can't just rely on it exclusively, to prove up certain facts, depending on the situation. But of course, the flip side is you'll have more leeway to get things in to help your client. If you want to put in documents or information or that have that can help them, show that your student is making an effort at school. When you're trying to build that case to keep them in school, good things they've done, clubs they've been involved in, you want to be able to just get that in. Those types of records that the student might actually just possess, showing some of their school history and the effort that they've had going through, and things about their backgrounds and histories. Because often, we'll talk a little bit more about this. Often the schools won't even know that these students are in foster care. It's not uncommon due to privacy rules. They just may not even know that the child's full history or backstory or history of placements or whatever the situation that led them into foster care. in the first place. And those are the kind of things that you may want to be talking about as you go forward. So yeah, we can go to the next slide. Okay. Rachel talked a bit about this already, and the bifurcation element. Again, so, it's always a little bit of a tricky dance to, if you do have a bifurcated hearing, how far are you going to go in the guilt phase? It's a very low burden of proof at these hearings. In the appeal section, they look at any evidence standard. So if there's any evidence that your kid did it, then they can essentially, find that the kid, guilty. So it's not beyond a reasonable doubt or preponderance of the evidence. It's any evidence. So it's a very tricky situation there sometimes, determining exactly what you want to do, but you can certainly go through cross-examination during that initial guilt phase to, if maybe things were, maybe the kid does have a good story to tell about what happened, about the incident, depending on what the incident was and the particulars of what they were facing or what they allegedly did. It's, you want to try to at least get that information out, as you would in any case, to tell the more complete picture to the hearing officer, if there's any mitigating circumstances, or a kid was provoked or pushed or bullied over time, or anything of that nature that could help the student in that part of the case. So again, Rachel, I don't know if you have anything particular here on these particular bullets to add.
Yeah, I think it's important to, as I said before, during the guilt phase, you may not have questions, but during the punishment phase, you may. And so you want to know when to ask your questions, because you may not want to ask anything in the guilt phase about it, but you may want to ask the same witness something in the punishment phase. So, and they may leave after they testify, and if there's sequestration. So you want to ask kind of, would it be appropriate to ask questions that are not focused on the incident now or later or whatever? I will give you another example. I did one and the teacher testified about what had happened, and the kid did it. I mean, he said what he said. It is what it is. But I wanted to ask the teacher the questions that Craig alluded to. Did they know that this child was in foster care? Did they know the child had been in a bunch of different schools? Did they, some of those kinds of questions? But it wasn't relevant to what the kid said, what he said. So I just asked kind of when I should ask those questions. And if it wasn't then would it be later, and make sure that that witness stays. So you just want to, again, it's okay not to know. It's okay to ask what you don't know, so that you're not like, oh crap, that teacher left and I had a bunch of questions for them, right? Like, just ask and say kind of what would be appropriate, and make sure, kind of that you're asking when you want to ask, what you want to ask at that time. And there's nothing wrong with doing that. So just make sure that you kind of know what's going on. But that's basically it there.
Yep, that makes all good sense. We could go to the next slide, I think. On general practice pointers. So yeah, so again, so this is different. It's a judicial proceeding. It's a quasi-judicial proceeding. You definitely have that feel. You definitely have that, court reporter. This is all under oath testimony, but it's not, federal court. It's not state court. It's not a criminal proceeding. It's not a civil proceeding. It's somewhere, something a little different. So you wouldn't necessarily treat it like you would, as these other proceedings. It's a balance between being a little more informal, but also, making your points that you need to on the evidence, on the story to tell. And how best to help your student, with the goal always being, what can we do to keep the kid in school? What can we do to keep that suspension shorter. What can we do? What is persuasive to tell the story that the kid had one bad day or a particular incident, and they shouldn't be out of school forever or pushed to an alternative school, which again may lead to a change in placement, and that's that's certainly another point you might want to an argument you want to make. Making your arguments effectively, true for any type of proceeding, any type of legal proceeding. That's just good global advice, and we can obviously, we're available to help you think through those things. We can get on a quick call to talk about facts of your particular cases as they come up, and what might be most effective in any particular situation on your particular facts. So it's what are the weaknesses in the school's case? Who was there? What was the incident? Who witnessed it? What went on? And again, what's your child's history? History here, good and bad, because you want to have that, be aware of the full picture, so you can at least have that information. And what are the things that really help you tell that story, to make these arguments effectively. And again, challenge the case put on by the school. The school will be prepared if the student has a lawyer, the school will very likely have their own lawyer to come in and put on that case. But there will be inevitably some holes in the case, I'm sure, put on by the school. Nothing's going to be perfect, so we just have to find a way, thinking through, all those issues to determine what's the best way to go. And like Rachel said, we don't want to be over the top. Just want to get your questions across, get your points across, limit your objections, certainly make the objections. And, we're not there to put on a show. We're there to just kind of be a helper as best we can, and be a facilitator, for the student, including potentially, and like Stan talked about, settlement, and different school districts are going to take a different approach on that, because some of your cases may, going to a hearing may not make the most sense if they did it, but you can certainly engage now that they know that the kid has a lawyer. Maybe they'll be a little more open to discussing a resolution that can work. But sometimes they won't be, and you'll have to go through with it. Rachel, anything on these points you want to throw in or add?
Yeah, no, I think that's all accurate and true. One question that we have is how much more time is spent kind of in preparation and negotiations versus the hearings. And Craig alluded to this, and we've all alluded to this, but in order to have, so when a student is put up for suspension, sometimes we cover this, sometimes we don't, but today we kind of shortened it because of this afternoon in the virtual session, and we want to get to the hypothetical. But a student's due process right is triggered when they are going to be out of school for more than 10 days. So the hearing has to be held within that 10-day frame. So when the timing spent on all this really kind of depends on how quickly does the case get to you, right? So sometimes you might get the case a day before, 2 days before, a week before. So you're going to spend as much time as you have prepping, right? Sometimes you don't have a ton of time to talk to people. You're going to be doing it more on the fly. Sometimes you get a plenty of notice and you're able to talk to your witnesses. You're able to talk to the school district's lawyer. You're able to try to negotiate and get to the hearing. The hearings last give or take an hour. They're not super long. So it really kind of just depends on how much time you have ahead of time to prep, how much notice you've given, how much information you've been given by DFACS or Georgia Appleseed when you take the case, and then is the school district interested in negotiating or not negotiating, or whatever you can kind of get done. Also, things settle at the courthouse, right? Things settle on the courthouse steps all the time. So maybe you couldn't get the school district's lawyer on the phone, or maybe you didn't know what you were doing and you couldn't find their information, or you were just caught up in doing other things, that day, take them aside, talk to them, see if there's anything you can work out. Appeal to the school district's kind of heartstrings, right? Did you know this is a foster kid? Did you know these things are going on with him? Did you know his backstory? All of that kind of stuff, that can work with the school district lawyer. I've seen it work. We've all seen it work. So, kind of the timing is just kind of, depending. Don't let the short timeline scare you off, because these are all going to be short. You're never going to have that much time. That's just kind of the way it works. Okay. Next slide, please. All right, go ahead.
All right.
Okay, I will take it away.
Sure,
Once the school district finishes, now it's your turn. Okay, so the school district have presented kind of their case, and now it's your turn. During the guilt phase, you can put on evidence showing that the student did not do it, right? Are there other witnesses? Do you have your child? Is there other information you have that you're going to present that the child did not do it? You may not have that. You may not at the guilt phase have anything to put up. It's okay. If you don't want to call your client to testify, don't call your client to testify. If you don't have an affirmative case to put up in the guilt phase, then you may not have anything to put up. You may, if your client, the child is telling you, I didn't do this, or this isn't true, or this is what happened, or whatever, then you very well might have them testify. But if they did it, you probably just kind of want to take it on the chin, right? And kind of say, no, we don't really have much to say at this point, but we do really want to talk about the punishment phase. And that's what you're going to do at the guilt phase. Again, witnesses, documents, or anything like that. At the punishment phase is where you're really going to put up the evidence of kind of what the evidence to try to mitigate the punishment. And that is going to be the most important piece, as we've said over and over again, of what you're likely to present that may work to help keep your child in school. Okay. Next slide, please. Okay, we've said this before. If there are charges pending, you want to consult the public defender. If they don't have a public defender, if you've got a criminal lawyer friend, talk to that person because you need to determine if the child testifying would hurt them in the criminal case. There are records of these. There is typically not an actual court reporter, but these are all recorded. So if your child testifies, it can be used against them in a criminal case. So make sure that that there are not going to be criminal charges pending, or that you don't think that there will be. And if you're not sure, err on the side of not having your child talk. It's better to not screw them up. We want to keep them in school. We for sure want to keep them out of jail, right? So if you're not sure, and the worst thing that's going to happen is they're going to be kicked out of school, but there's still criminal stuff going on, or it's too much for you and you don't know, err on the side of not having them testify. With that's fine. That just kind of is what it is if you can't get the information, but that's what you really want to do. Okay, next. All right, so let's talk about, okay, so okay, so some of these are a little bit kind of repetitive, but during the guilt phase, you get this is again repeated. At the guilt phase, you get to cross-examination. You may not have witnesses, all of that. Okay, next slide, please. Now, at the punishment phase, the school district during this phase is going to present the student's grades, good, bad, or otherwise, a discipline tracker. This is the other discipline that maybe the child has been involved with, and any other relevant information on the student that they want to present, okay? Sometimes teachers write statements. Sometimes teachers write positive statements, and these are put forth by the school district at this time, and they will put forth their proposed punishment. Suspension for how long, opportunity to go to alternative school, when can they come back, all of those kinds of things. They will put forth this evidence. This evidence can be helpful to you. Are the grades good? Do they not have other discipline? Or did the teachers write positive statements? Joy to have in class, like teaching them, those kinds of things. It can also not be good for you. They're failing all their classes and they have 22 other things in their discipline tracker, and the teachers write misbehaves, off task. It is what it is, but these are the things that the school district is going to put forth about the kind of child's general just education type of stuff, and then they will put forth their proposed punishment. Okay, next slide, please. Okay, you will now be prepared to present your evidence on why the student should remain in school. Okay, or why it should be less than what they're proposing. So sometimes that's all you can do is kind of shorten it, but why is the punishment too much? Why are you doing the plea? We call it an impassioned plea to keep this kid in school. What evidence are you going to present? Okay, so can you go to the next slide, please? I can't recall what's on the next slide. Okay, here we go. All right, if your child has violated the school rules, you can help them write a letter of apology that they can read during this hearing. Hearing officers love this. They love to see students take responsibility for their actions and apologize and talk about how it's never going to happen again. Okay. Now, I generally like to have the students write this themselves because I am not a high school student. I am not a middle school student. If I write it, it's going to sound like I wrote it, right? Let the child write this themselves. Give them guidance about what it should have and have the parent help them to some extent, or the foster parent, the defects worker, and then you read it after the fact, okay? I tell them to write this down. This is going to be something that they are going to read at the hearing. Because why? They're going to be nervous, right? We all get nervous. We as lawyers get nervous. I still write down a lot of what I say at these hearings and any hearing I go to. And so we want to make sure that they read it and that they get all the points across that they want to. They're probably not so good at talking on the fly like you may be. So have them write this up. They need to say that they are sorry, that they know what they did was wrong, and why it is not going to happen again. This goes such a long way with hearing officers because they really, really want kids to take responsibility. If you have it, you can also have other witnesses testify about the student's character. The foster parent, does the foster parent like having this kid? Is the kid good in their home? Do you have the defects worker who can talk about this? Do you have other people? Is the child involved in any extracurriculars? Does the child go to a religious institution, church, synagogue, something like that? Can any of these people come, a therapist, testify what they're doing to help this child, about this child's character and what is being done so this doesn't happen again? They can also testify about the child's past and the trauma, right? That's what Dr. Gaithing was saying. What has this child been through? What trauma? And bringing that home. This child has been through 10 foster care situations. Do you know, Judge, that every time that a child goes to a different foster care, they lose like a year of school, right? Talk about those things. It's okay. Have a witness testify to that, right? Have a witness testify to the care placements that they've been in, the amount of schools that they've been in, the help that they're getting them, the stuff that they're lining up for them. Who signed it? How did they come into the defects care? The case that I did, the mom signed the child into care. I mean, that's tough for a kid to know that his mom signed him into care because she didn't want him. I mean, have those things come out by your witnesses, because this is where you can really, really tug on the heartstrings of why this is so important to keep this child in school. Okay, next slide. Okay, before we get to the hypothetical, go back to the slide because I want to talk about a couple of other things. You can also bring in documents at this time. What is in the defects file that is helpful to you that you can bring in? Is the child a special education student? You are going to hear that the hearing officer doesn't care and doesn't want to hear about that. Say, thank you, Your Honor, but I do think the IEP would be helpful. Do you have a psychological evaluation that is helpful to you? Remember what we said, if they put in hearsay, you get to put in hearsay, right? So I had that happen to me. They put in hearsay and I said, Your Honor, I'd really like you to read this. And they said, nah, it's hearsay. I'm not going to do that. I said, thank you. I understand that. I would just like to put it into evidence, knowing dang well nobody's going to read it, but at least putting it in there, right? Do you have those kinds of things? Are there psychological evaluations? Are there can you if you don't have a live witness, get them to write a letter. Ideally it's notarized, but if it's not, it's not. Get them to write a letter about the student, about their character. Anything you can think of to put into about how this child has been through so much, and also in addition to that, how they've been through so much and what they've been through, but are they a good kid? What is being done to help this kid so this type of thing doesn't happen again? These types of witnesses can go a super long way. You also may want to have your witnesses write out the statement. If it's a foster parent, have them write out a statement, right? Because again, they're going to be nervous, and maybe it's better coming from the heart as opposed to you asking questions, right? Because they can get nervous. They may not say what they want to say. So a heartfelt written statement is huge from anybody, okay? Get letters if you can. Friends, family members, other family members, there are other foster care kids in the place. Anything you can do to think of, if depending on the time that you have, to mitigate the punishment. This is where you are making, as we call it, this impassioned plea to try to keep this kid in school, right? And anybody that you have to bolster that, good, bad, or otherwise, right? The bad is kind of, oh my gosh, this kid has been through so much. Don't throw them away. Help them, don't hurt them. Or the good, they're a good kid. They got in some trouble. They're a good kid. They're finally in a good placement. They're finally getting the help. And let's try to help them, not hurt them, right? These types of things go such a long way on keeping your kid in school. I want to talk about the decision, but before I do that, Craig, do you have anything to add on any of this?
No, that's great.
Okay, so then at the end of the hearing, you will get a decision. Now, you may get it that day. In Rockdale and Cherokee, they give it to you that day. Sometimes it's mailed, right? You want to make sure if it's going to be mailed, where is it going to be mailed? These are some of the issues we have with DFACs in terms of who's kind of the custodial person that's going to get it, and you want to make sure you're getting a copy, right? So you want to say, please make sure I get a copy, because as Craig's going to talk about a little bit later, the appeal timelines run quickly. So make sure you get a copy. Sometimes you get it right then. In Rockdale County, the decision took as long as it took him to walk back to his office to print out the pre-printed decision that he had already done with the punishment and bring it back to us, okay? In Cherokee, I believe they handwrite it. You may leave with it that day with kind of what the decision is. If the child, generally speaking, children get the option to go to alternative school. They're suspended from their regular education school for a period of time with ability to enroll in alternative school. So they'll give that information on kind of how to enroll in alternative school. What does that look like? How do you get in there, and how does that start? And then how does their stint in alternative school end? When does that end, and what can they do to get back? So you want to make sure that you get a copy of that, whether it's that day or whether it is later in the mail, because of these appeal deadlines and timelines. And again, you should know what the school district is proposing for their proposed discipline. And so you'll know if you've beaten that by getting a lesser punishment, by mitigating the punishment of lessening it, or having, if they wanted to suspend for the entire, like let's say the tribunal's in October and they want to keep the kid out for the rest of the school year, and maybe you get it just the semester or something like that. So these are the things that kind of you're doing to again try to mitigate the punishment, and you're gonna spend your most time on this prep and your most time in the hearing on this, because this really is where you can make the most difference. Okay, Craig, anything to say at the end of this to wrap this up?
No, I mean, other than you always have to know your audience, as usual. And a hearing officer may or may not be someone with legal training. If it could be a long-time school employee. So you're making arguments to a fact finder who may not be a lawyer. So you don't want to necessarily come across as too lawyerly. When you're doing this, you have to represent your client zealously as you always would. In your day-to-day practice, but at the same time, you want to be conscious of, how you're presenting things to someone who would not have the same legal training that you or I would. But at the same time, you're also likely looking at people who've done lots of these hearings, so they've heard lots of things and lots of different arguments. So they're not going to be totally, fresh to any of this.
Okay, and we're going to do a hypothetical, so we'll talk about some of this in the hypothetical as well, so you can try to get a little bit more of like a real world, just spin on this, I guess.
And first of all, thank you, Rachel, Stan, and Craig. We are not close to being done on this, and as Rachel said, we're going to take some practical steps. What we're going to do here is we're going to take a 5-minute break. I will post the hypothetical on the screen so you can take some time to read it. You can take a little bio break, and we will start back with our panelists, expert panelists, providing answers to some questions about it at the top of the hour, 3 o'clock. So I'm going to switch it out, and know that as you read this, I believe that I've made the modification at 16 years old. You will have received this hypothetical in your in one of the emails from Zoom, but we wanted to give you time to look at it before we dive into it. So I'm going to pull that up.
Yes. And the reason why the age is important is because it is not, the child can drive. It's okay. So one of the hypotheticals that went around was the child was 13 and driving and all of that. And we don't want to get lost in that. That's not a relevant fact. So the child is 16 and can drive, focus on everything else.
Right. Just a second here and I will get it up on the screen. There we go. I'm going to zoom it in a little bit. And for those of you who are new to Zoom, I want to share that. So I've made it larger on my screen, but also if you will go to, I have to think because my screen is different. It will give you view options on your screen if you move your mouse around, and that will let you expand the size on your screen. And so we're going to take 5 minutes. We'll have all of our panelists back. We're going to add to our panel, actually, Michael Waller, who's the Executive Director for Georgia Appleseed, who has extensive experience doing tribunals, as well as LaShonda Woods-Roberts, our staff attorney, and who has been an Equal Justice Works Fellow as well. But we'll be here to answer some questions, and we're going to look for your insights too. So 5-minute catch up, bio break, and we will dive in. All right. So just take a second to let everybody get back to their chairs, maybe finish up the snack you grabbed during the short break, and get all of our panelists, Michael and LaShonda, Kimara, Stan, Rachel, Craig, if you will come back on screen and we'll begin to walk through this. And as people come back, one of the things I want to share with you that I hope you've already figured out is this is about a team support and you engaging in these tribunals. We have the training manual, we have these trainings, we will do more trainings going forward, more hypotheticals going forward. Part of why we want to do this today is, again, to the closest we can, have a practical application to all the wonderful insights that our panelists have provided. When you take these cases, the Georgia Appleseed staff is available for you to answer questions. Our remarkable team with the YPC TVLN, the subcommittee, is available to support you. So you'll see that as we go in, there's a lot of expertise that's going on. And with that, I'm going to throw out the first question. I'm just going to, we'll sort of popcorn it, y'all jump in. And as participants, again, if you have questions or you have comments about the questions, if you will put them in the chat, we'll make sure to share those out as well. There's also a feature where you can raise your hand and we can see too what you'd like. But here we've got this young man who's facing a tribunal. He's got a little bit of trouble, partly not of his own accord, partly of his own accord. What are we going to do going forward? This may be even more than you get when you first get the case and the assignment. And so the question we have is, what do you identify as the most important facts in the case? So with what you have right here, what are the most important facts? And I'll ask our panel of experts just to jump in and share what your thoughts are.
I'll kick it off. This is Stan. For my part, I look for the notice at first, and I'm drawn to what appear to be defects in the notice. They don't list what part of the code of conduct the student violated, and it was sent to his grandmother, but not to his legal guardian. So I might think about getting this completely thrown out on procedural grounds, or at a minimum, they got to send another notice, which buys us some time to get ready for the hearing.
And I'm going to do a follow-up question with you, Stan. Talking about the notice requirement, what is the specific argument you're going to make? What are the facts what should have happened that they didn't do? Because remember, we got a bunch of people in the room who have not done a tribunal at all.
Right. So I would, it's something to think about, as far as, just waiting till you get to the hearing and springing it on them then that the notice is effective. But ultimately, how is that going to play out? It's possible at the school board, the hearing officer just says, well, that's nice, but we're proceeding, or I don't believe that's the case, and just goes on ahead and proceeds. So you might think about raising the issue in advance. And as I see someone has just pointed out, raising the issue in advance in writing and serving it to preserve it is probably the most effective way of handling that issue. And ultimately, they may reserve the notice and may cure it. They may not do that. And if they don't do that, then you've got an ace in the hole for later if there's an appeal.
Who should have gotten the notice?
Well, they should have put the portion of the code of conduct or some statement of what the student is being accused of doing. And again, they can't change that midstream. And so in this instance, it could be any number of things that they might have put in there. But if you don't have notice of what he's being accused of, then that's not going to satisfy the due process requirements.
Great, thank you. And to the point in the chat about doing it in writing, while these are informal hearings, the formalizing what you're doing will help you on appeal, which we'll talk about in a little bit. And we'll also show those who are making the decisions that you mean business, because we know you do. Any other thoughts on the piece that Stan has raised or other important facts that are here?
Well, I'll I'll raise something different, I guess. And so my name is Michael Waller, and Carolyn, it's nice of you to say that I was an extensive experience, but I represent, what I have expertise in is having come to tribunals with no prior expertise or experience. So I can talk extensively about what it's like to be in your first tribunal, not feel like you know what you're talking about, but nonetheless have a really tremendous experience and do wonders for the person there. So I'm a real live example. If you don't trust Rachel and Craig and Stan at this point in time, if they've done too many and they no longer have credibility, I can tell you that what they're saying is true. What I noticed, just kind of, when you look through the fact pattern and you think about how you yourself are going to incorporate, you're going to hear the facts. And there's right at the beginning for me, kind of a check about your own preconceived notions about this kid. Because the way this fact pattern was written, which I think is really artfully written, it starts out with what he's accused of. And so for a lot of us, whether we've actually been involved in this kind of thing or we haven't, we may have a preconceived notion about what that says about the kid. And then there's the next fact, which says something really important about the story that you're going to want to explore and find out about. And that's the last sentence in the first paragraph, which is that his grades have suddenly started to drop in all of his classes. And so right there, that there's a story that you absolutely have got to tell about this child, this 16-year-old. And you need to ask questions. You can't assume that because John has been accused of bringing a gun to school and getting into a fight, that says something about sort of his character or who he is. That in fact, what we like to say at Georgia Appleseed is that behavior was actually an effort on his part to communicate something and something that has happened to him. And so right there in that first paragraph, there's a clue about what's going on. And you may not, if you're not careful about your own preconceived notions about a child who's in foster care or who's been accused of something that's serious, you may forget to ask a simple question like, what were his grades before? What were some of the other patterns of behavior before this one presented itself? And so you want to think about your client really broadly as a child with a history, and that this most recent behavior is an effort to communicate something to the school and the community that he's in.
Great, thank you, Michael. Other important facts, we've got some defenses we'll get to that are showing up in the chat, but as we're looking through at this, are there other important pieces about what's happened to John, who John is, what we know? Yeah, Craig?
Yeah, certainly this history of bullying is, I think, another important piece to bring up, certainly for the mitigation and possibly for the act itself, possibly as part of your defense. I mean, the school, and you want to put it this way, the school was certainly on notice of a problem. Not only was there bullying, but he told the teacher multiple times in advance leading up to this incident. If the school had taken steps, or if the teacher had stepped in, or the teacher had raised it up to someone more senior, whether it's a principal or somebody else, you could have, forestalled this whole thing, potentially part of the incident from happening. So again, it's not going to likely take the kid off the hook for the act, but the school is not blameless here. If you're trying to mitigate that punishment.
Yeah, and let me say something. So this hypothetical we wrote for you all to have all the facts. When you take a case, it's not going to be laid out like this. So I just want to back it up for you all. These are the questions that you want to be asking the child. I think Michael said it, but I'm going to say it just in a slightly different way, right? Of kind of ask. It's not just, okay, you brought a gun. That's what you're being accused of. This is going to be really hard. Weapons are really hard. Guns are even harder. Like, you're screwed, right? Like ask the child what's been going on. Are you having trouble at school? What were your grades? Did they find out? Because you're going to need to elicit that information from your client to then be able to do something with that, right? So don't make assumptions. I mean, I read that first sentence and was like, oh my God, a gun, you're dead in the water, right? Like that's so serious. And of course, schools take guns very, very seriously, as we want them to, right? That's not, but kind of the deeper dive and asking your client these questions. So when you talk about preparing, you want to ask them, like I just said, are you having trouble at school? What were your grades? Are you doing okay? Why, did this kind of escalate and all of that kind of things? And also, how did the gun come to be in his car, right? You're going to have to elicit that information from your client so you can find out, because to me, that's a huge fact, right? That he brought it really unintentionally to school, right? That somebody else left it in his car. I don't know that that will work at the hearing, but you're going to try everything. So one of the other things is that at this punishment phase, you argue everything because you never know what's going to work, right? So you want to be arguing everything, that he didn't know, that he's been bullying, that his grades have dropped. You're going to just any fact that you have, you're going to talk about. So to me, that he didn't know that it was in his car and didn't have the intention to threaten this kid with the gun until he saw it and probably thought, oh yeah, that could be good. Because why? That's an impulsive mood. That's an impulsive thing that he did, right? He saw it and probably thought, oh, this will be good. This will give me some leverage, right? That's impulsive. Go back to that first sentence where it talks about that he has difficulty staying on task, okay? Both of those are symptoms of ADHD, right? And so impulsive behavior, attention deficit behavior, all of that kind of stuff. So those two things could be very important to you if you have a special education situation, right? A mitigation of the punishment, manifestation determination, all of those kinds of things. So to me, this impulsive behavior is also very important. But I just wanted to convey that these are the facts that you want to be asking your client. Don't make assumptions. Ask, try to get the story from your client, from the foster parent, so you can try to see what's going on. Okay.
Thanks. And two things I want to point out that jump from what y'all have said. One is you'll notice in the first sentence it says was suspended. And you maybe, those of you who aren't familiar with tribunals may say, well, if he's already suspended, why is there a tribunal hearing? I think they touched on it during the training that up to the 10 days he's out of school for that period of time. The other piece is, as you're thinking about getting the information from your client, we will talk in another training real in depth about how do you build a client relationship. But going in and saying, I know you did this and you got to tell me, they may shut down. It may be a different fact pattern where you got the gun is found in the car and he really didn't know it was there. We've made it easy because he takes the gun out of the car. But how do you engage with that young person when in fact they really didn't know the gun was there? The other piece is, as you're doing all of this, as you're talking to your client, as you're looking at all these different factors and behavior and what you're seeing in the records, remember what Dr. Ayo said, excuse me, and that is we're dealing with children who are still developing, aside from the complexities that are there. So those might be there. And I just real quick, any other important factors that you all see that you would hone in on going forward? And then we'll move to the next question. And there are some comments in the chat about different pieces in terms of, so Paul is noting that he was not living with his parent, and how does that impact him is another fact that you would focus on. And then Jason's taking us into the next question. Can you get his disciplinary hearing? Craig or Stan or Rachel, do you want to touch on that? You're muted.
Okay, sorry. So the question is, can you get Kevin's disciplinary history, but our client is John? And the answer to that is no, you will not be able to get Kevin's disciplinary history. Another child who's not your client. So if you meant John, who's our client, then yes, you should be able to get that. If you meant Kevin, the other student, then probably not. In fact, no. I also
talk from a. Go ahead, Rachel, go ahead.
Okay, so the other, so he's charged with taking drugs, weapons, and threatening others by using force, but there really is no evidence of taking drugs. Maybe there were drugs in his car, maybe, but there does not seem to be any evidence of that. So kind of, why they're doing that and what's happening there. So those are some things that you may want to explore and kind of talk about that and kind of, the deeper dive on why they're doing this drug charge when it doesn't seem to be relevant to this, to that he's being charged with taking drugs. I also want to say another thing, as we talked about, well, we didn't talk about it today, but children check their rights, a lot of rights at the schoolhouse gate, so to speak. And so they probably could search his car by virtue of it being at school. And if they found drugs in his car, maybe that's what led to this drug charge. But they would have the right to search his vehicle, I think.
And before we get to the question that's in the chat, I want to pause for a second, because what we've done is we've gone down the road. We're preparing for the hearing. But can you each maybe give one thought on the child is our client. That is the person that we represent, we're fighting for, we're working for. And so you've got to build that client relationship. You need to engage and talk to them. From a practical standpoint, where do you do the interview? How do you connect with them, and when do you do that?
So I think that depends a lot on the timing that you have, and the location of everybody, and whether you're not in a pandemic or not. So ideally, for me, I like to meet the kiddos face to face, maybe not even at a conference room, maybe in my office where I have a couch, something like that. In a pandemic, that's probably not so practical. Can you do a Zoom call with them? Something like that. But also, I have talked to these kiddos sometimes just on the phone. Sometimes that's the best that you can do. And you just want to use kind of your best non-lawyer kind of language and tone and all of that if you're on the phone. But I think a lot of that depends on, can the child get to you? Can you get to the child? Can you get out to the child's house? Do you have the time to do that? Are they close by? And again, we're certainly would never ask anybody to do something that they don't feel safe with. So we're giving this presentation in the middle of a pandemic, but kind of non-pandemic times, you would have some options to meet this child in person, hope maybe even on their turf, their house, a public place, a park, something like that. And, it kind of just depends. I think the answer to that is it just kind of depends.
And Rachel, if I could follow up on that. So first of all, and Paula's got a great comment in the chat that I'm going to lift up, and it's, she's gone to their houses and gone on a walk with them. That idea of a walk, I think, is actually really a great if you can work it out, and if you can do it in such a way that everyone's sort of feeling comfortable and safe about that. And I think, as a practical, thinking through sort of on a practical reality, it's safety that you really want to create. You want to create a feeling of safety. And you also want to make sure that you yourself are willing to create moments of silence. It's not my forte to do that, but it is something you have to do. You've got to actually wait and let the client answer. And that may take longer than you expect. You also need to let the client direct, especially when you're dealing with younger people, you need to let them direct the conversation some, because they're going to work their way into sharing information with you. They're often in a position in a way that a lot of other people may not be, adults aren't, where they're really sussing out when talking to you sort of what they think you want to hear, what they feel safe sharing with you. And they're also, these kids spend a lot of their time evaluating risk and like what's a risky thing to share and what's not. So their incentives for telling you the truth may be different from what you think is reasonable. Like they may have good reasons they think not to share additional important facts with you because they have concerns about it getting out to their foster parents, getting out to other foster kids in care, people at school, that sort of thing. And I'll give you an example. There could be part of the story here where there's bullying and it has something to do with someone's sexual preference or sexual orientation, that sort of thing. And that client may have good reason not to share with you that fact. And so you've got to create a space where the client feels safe sharing information with you. And that may be, you have to give them space to do that, which may take a little bit longer than you think. And it may involve a little bit of silence on your part to wait for that to happen. I would say as a practical reality, if you don't have experience working with youth and children, this sounds silly, but go on the internet and Google how to effectively talk to children, and this is, as a parent, that's something I've done, right? And there will be a few sort of concrete suggestions that you'll find in different places about sort of little steps for you about how to sort of engage and wait and use silence and those sorts of things. So that may seem silly, but don't think that that's outside, you know, using those kinds of skills is outside the realm of lawyering. I mean, that's a really important part of this.
And I'll say to Michael's point, don't ask the hard questions right away. Take some time to connect with them and ask some questions about what they like or how they communicate. And that might even help you as you work to mitigate any particular potential punishment coming. But it's important to hold the harder questions until you've created some type of connection with the youth, because you don't want them to shut down right away. And we definitely don't want to traumatize any kids. So I would suggest holding the harder questions and really offering some of yourself so they can get to know you and asking some questions to learn more about them before you go into great detail on the actual offense itself.
I totally agree. But I sometimes try to be the practical one here. Do not let this conversation scare you off. We don't expect you to be child psychology experts, and please don't let this conversation scare you off. Do the best you can. You know what I said earlier, read the room. Maybe you're not going to get, anything out of your child, and that's okay. And you're going to do the best you can. And one of the things that you're conveying to them is that you're there and you're in their corner, even if they don't want to talk to you. Sometimes teenage boys, if you're a female, they don't want to talk to you. It takes longer to build that rapport. I don't have as much in common with a teenage boy as I might, somebody else. So, it's okay. Do the best that you can with the skill set that you have. It's okay. The more you do this, the better you'll get at it. But if you don't have children or you don't have experience with kiddos, that's okay. Please do not let this conversation scare you off, because we all do the best we can. And that's okay. And if the only thing you have is a 15-minute phone call the day before the hearing, because that's all the time allots, do the best you can on that call, and that is totally okay.
And the other piece in all of this, when we think about what we're engaging with a young person about, it's not necessarily their whole history. LaShonda talked about not traumatizing. You can have records. And so it's really just that. What is my role as your lawyer? I'm here to represent you. And let's talk about and walk through it. It is what Rachel's talking about, that it's a smaller nugget in this type of context and not going into what got them into foster care, unless they want to talk about that. And some of that is open-ended questions. So really good feedback. Thank you, everybody. Jason Marcus put a question in the chat and asking this. Can you introduce other evidence such as witness testimony of Kevin's history as a bully? So again, going back to the idea of how do you get some of these pieces in, perhaps without having John have to testify?
I think that's going to be a tough go. You can certainly try. Does John have a friend that's willing to come and testify that Kevin is a bully and that Kevin's been bullying John or something like that? To get that information, you're going to have to get John to give you some names. So it really probably is going to depend on the rapport that you've built with John and his willingness to discuss the bullying and some of that. Also, you can subpoena people to come, but they don't have to show up. And also subpoenaing a child that you haven't talked to, that you don't really know anything about or don't know their parents, may not be the best option. So I think the answer is, I think that that's a great idea. And this is an issue spotting hypothetical. And so I think that that's a great idea and something to possibly explore. And the answer is you can do that. But I think you're going to run into some realistic problems with it, but I think it's a great idea, option, and thought to explore to see if it's something that you could bring in to do. Yes. And maybe where you would, sorry, I was just bring in maybe a witness statement, is somebody willing to write a statement on behalf of John or something like that? And, certainly maybe exploring that. Some of this is going to depend on the time that you have as well.
Well, and the other piece is under this fact pattern, it said that he has taken it to the school. He's told the teacher about the bullying, right? And so you can talk to the folks who the report out is, and so to think of it that way. The other thing, just one more piece, and Paula's mentioned in the chat, and this is beautiful. Instead of saying what happened to you? What do I need to know? If you come in saying you've done this, and you're essentially, the impression is you've done something bad, they're going to shut down. So thinking about open-ended questions. This is all really wonderful. I do want to take some time talking about, we talked about IEPs and the importance. We focus on that in part because it's a specialty area. It's something for you to know and be aware of and look for. We don't see here that John has an IEP. So we don't actually know because it doesn't say yes or no. And sometimes what we get in our referrals is they don't know if the child has special ed needs. The important piece, though, to take away in part from what Kamara talked about was they don't have to have an IEP. It may be that there are factors that would lend to there needing to be that identification. How does that play into your analysis of your strategy going forward with this particular case?
I think for me, it will play in greatly because gun charges oftentimes are associated with zero tolerance policies. And a lot of times it's for a whole calendar year. And if there is some type of evidence that the school had knowledge, and from the facts, it seems that multiple teachers were noticed or had noticed that he had difficulty staying on task, as well as following classroom expectations, et cetera. So arguably, even if he hadn't been identified, he could technically be protected under IDEA because there was notice and they failed their affirmative obligation to identify him. So I would definitely consider that as a potential part of the strategy, because if a child is, we can argue the impulse piece and we can argue that, but under the IDEA, even for interim alternative education settings, there's no knowledge component. There's a knowledge piece with drugs, but if you have possession, you have possession. So I think that considering how grave the outcome could be when it comes to guns, if he has some type of evidence that he should be identified or at least evaluated, that's going to be a big part of any type of strategy I build.
Shonda, thank you for that. Will you just again, for the people in the room, IDEA stands for what?
And that's the Individuals with Disabilities Education Act. And it covers special education and related services for kids who have one of the 13 identified exceptionalities.
Thank you. And I want to remind everybody, it was put in the chat earlier, we're going to do a follow-up email with a lot of resources for you, because again, there is a team supporting you as you do this volunteer work. In the Tribunal attorney manual that we have, that we will send you the link to, this information is there. So I'm sure you're taking copious notes. But there are other, you will have these resources in writing. Rachel, did you have a comment?
Yes, because this special education piece. So one of the things is you should totally bring it up at the tribunal, and they are 100% going to shut you down. Okay. At the tribunal, they don't want to hear about the special education piece. Okay. But you still want to bring it up because it's relevant. Can be relevant to the mitigation of the punishment. It's relevant to IDEA. It's relevant to possibly getting an IEP, getting them tested, getting a manifestation. But at the tribunal, they're likely going to tell you that they don't care about it one way or the other. The tribunal is, he's accused of this. Did he do it? Right? And not the whys, not the hows, not the whatevers. You should bring it up. This is an argument that you're going to bring up, and you're going to respectfully be shut down, or hopefully it's respectful, and you're going to respectfully say, thank you very much. I just want to make sure that you're aware of what's going on with this child, right? And and you want to spin it that way, as opposed to that he is not, that should he have an IEP, that they failed him by not having an IEP, all of those things. That's not going to work at the tribunal. You're just going to say, I just want to make you aware of some of the things going on with this child that I think would help in talking about why he did this or what punishment is appropriate. So I just want to make that distinction, because the tribunals are so narrowly focused, and the special education piece is so big, but at the tribunal, they're just not going to care about this piece per se, but it is certainly something you want to be aware of and bring up.
And if you have time before to really get into the records and you see that there was knowledge by the school, if in fact he should have been identified before the discipline occurrence happened, you could technically argue for an MDR. And if the child is found to have a disability and it's a manifestation, there might not be a tribunal. So if you have time to explore it,
that you're going to be arguing to the school district's lawyer. At the hearing officer at the tribunal is not going to care about that. That was just my point.
Agreed.
But you should totally be aware of it. This is a huge issue to spot. You're completely right about that. I just meant if you're already in the tribunal, that's not going to work. Just saying.
And LaShonda, your point is a perfect segue so the expertise on this panel, in addition to being lawyers, LaShonda and Kamara have been teachers and educators. So my question to you all, LaShonda and Kamara, is what are the school records that we might be looking for? As the lawyers representing the child in these cases, we talked about IEPs. Going in as a first-time lawyer, what should I be asking for?
I think it goes all back to the mitigation piece. If he doesn't have a significant discipline record, that could obviously support a smaller penalty or outcome. And the special education records may include a behavior intervention plan that might call attention to that impulsive behavior or something that supports the self-defense argument, or some previous bullying that he had experienced that caused other diagnoses to come to fruition. So I would say, to a minimum, the special education records, the discipline records, and any teacher notes about what they've seen. While we might not be able to ask, like Rachel said, for Kevin's actual discipline records, we could probably ask for any notes of examples of when Kevin and John had any interactions in class or on school grounds.
I think when looking at the IEP as well, thinking about looking at what services the child has been offered, if they have actually been getting those services, if it's been a decrease of hours, say for instance, they're supposed to get a certain amount of hours of a certain type of service each week. And if there's been a decrease, but you also see that there's been an increase in behavior, anything that could point to maybe this child is not getting the support that they actually need, that should be laid out in the IEP as well. So it's not just looking at the IEP, but looking at it to see if there's any discrepancies within it as well.
Thank you. The other piece I want to remind us is that these children are in foster care. And there are going to be people in the school that are resources for you. They're ESMs, education support monitors. There is the foster care worker who knows this child well. And so you want to include in your information gathering a conversation there. They often can be one of the best advocates for that child at the hearing or in your preparation. And so I want to lift that up as well. Noted too in the chat is looking for psychological and psychiatric reports. Attendance records, education records, look to see if there have been any truancy issues, if there are grade drop-offs, what types of classes they're in, and maybe some of the conversation with John when you meet him is, what's your favorite class in school? I would have answered back then that it was physical education and recess, and then as I got older, it would be math. So those are just some considerations there to go into. One of the questions that we've had is, are there any challenges that you have run into in getting the records and getting the background that allow you to go forward, and how have you dealt with those? No challenges. Any challenges in obtaining the records?
Come on, LaShonda. I think you've got a very recent example you could share. Right?
Yes,
We do. I won't say the district, but there was an exchange with a school district attorney, and we asked for the records, and they directed us to the school to ask for them. And of course, we want to communicate with the attorney if we know the party is represented, but there was pushback, and we never received the records. And they said they were glad to share them with us when we get to the tribunal, which would not help us prepare adequately. But of course, parents can always request their child's records under FERPA. So there are the family education. Y'all help me out with that one. But FERPA, of course, the privacy piece when it comes to education records and Privacy Act, that's what it is. So some of the attorneys for the districts have not been as quick to share records that they are using and preparing with. But there are ways to work around that if you find that to be a challenge, but there is no requirement for discovery right now under the law. So it can be very challenging and look different in different districts. Some of them may share it ahead of time. Some of them may share it with you as you're walking into the door. But if you can find a way to get to the records, maybe through a request from some type of release or something and get to the school directly, you might get it that way.
And just be nice too. Sometimes you get it by just being nice. You know, it's okay to say, I'm a volunteer lawyer. I don't really know. It'd be really helpful if you would give me that. Like, it's okay. Just, I mean, you know, be nice and maybe you'll get it. And then maybe they won't. And then you just do everything on the fly. And that's okay too. Again, we know you're going to do things on the fly, but one of the things is just sometimes just asking and being nice is the way to do it.
You'll note that
doesn't always work, but sometimes.
The recommendation about using a subpoena or Opens Records Act, some of that is talked about in the manual. The other piece is if you walk in the door and they say, here's what we're going to rely on. Here's some reports, here's some witness statements, here are the school records. It is all right to then ask for more time. And again, as Rachel says, if you do it in a way that's nice with the hearing officer, they're going to want to move things along. And part of it is to say, if you give me some time to review this, we're going to move along a lot quicker, even if that's 30 minutes and we have the hearing, or give me a day. Make that request. Don't let them, I was going to say, don't let them push you around. But all right. Well, we will, as the spring comes through, there will be more opportunities for us to do hypotheticals with you all. We'll have more trainings on that. You've had the hearing. You've gathered your information. You have knocked it out of the ballpark. You've been ready for every witness. The child is grateful because they have been heard in this hearing in the way that you have represented the child. And so you get a decision. What do you do next? We're going to go back to our PowerPoint here. And talk a little bit about that. All right, these are our questions. So at the end, and Rachel and Craig, I think this is you talking about
Sure.
it.
Yep. Yep. Thanks very much. Yeah, I'll run through this quickly. So when it's over, for the purposes of our project, you don't have to take an appeal. We ask you to handle the case. We'll get the decision, and then that's the end of your commitment for the purposes of our tribunal project. But you should be aware, and it has happened before, that people will take a case and then decide to take an appeal if you don't get a decision that you don't like. And the big things, and I'll run through it quickly, the information on the deadlines and how it works is all in the manual. There's an entire chapter of the manual. It's a few pages that's dedicated to this. Know that you can appeal, and know that the deadlines to do so are tight. That's the big takeaway. So just some of the quick particulars. Again, like it says, you have a right to a written decision, and that has to come within 10 days of the close of the hearing. Often you get the written decision on the day of the hearing, but it has to be within 10 days. That decision must solely be made on the evidence presented at the hearing. And then if you choose to, you can appeal that decision to the local Board of Education. The appeal has to be in writing and has to be submitted to the local Board of Education within 20 days from the date of that decision. One important practice note, the 20 days is not extended by holidays. It's not extended by weekends. So keep that absolute 20-day deadline in mind. Also important, you can make a request to suspend or hold the disciplinary action against your kid, against your client, during the pendency of the appeal to the local Board of Education. They don't have to do it, but that you can make that request. So you make that appeal, that's in writing, setting forth your reasons and what they got wrong in that written appeal. The local school board then has 10 days to make a decision. Some districts will allow an oral argument, others will not. So that's the first part of the process. Once you get past the local Board of Education, you can appeal to the Georgia State Board of Education. You have 30 days for that written appeal. Have to file a transcript, the local board's hearing along with your appeal. But at that point, if you're going to that second stage, the decision of the local Board of Education will not be suspended during the pendency of that appeal to the State Board of Education. The appeal gets docketed, then you have 10 days to request oral argument, 20 days to file a written brief, then it becomes 40 days from the date of docketing for the opposition. There's a hearing, and then the State Board of Education has 25 days to make its decision. Always keeping in mind, of course, the standard of review is very, very difficult to overcome. Any evidence, and I don't know if I've seen it in really any other circumstances, any evidence to support the local Board of Education decision, unless there's an abuse of discretion, the decision is contrary to law, or if it's arbitrary and capricious. So it's a very tight road there. And just know from the State Board of Education, you can't appeal that. One more place to go is the Superior Court, and then you have 30 days to do that. So those are the deadlines, and that's kind of the process. I know Rachel has had success in one instance, appealing one of our tribunal cases. You want to have a quick story about that one?
Yeah, so we don't ask you to do the appeal, but sometimes you just get so fired up. And so the one where my hearing officer testified, I got really fired up. And the facts of the case were the tribunal was early in the school year, maybe I want to say September, give or take. And the child had spent most of the school year not in school. And the charge that he was brought up on was like a cumulative insubordination charge, right? So he was mouthing off. He got out for a few days. He came back. He was mouthing off again. He got out for a few days. And so by the time that he got to tribunal, it was his 4th time out of school. And so they were allowed to suspend him. And he was mouthing off to a teacher in the hallway. He had been in a ton of different schools. He was brand new to this school. And this is the one where his mom had signed him into care. And nobody knew he was a foster kid. Nobody knew anything about him. Nobody bothered to find out anything about him. And they were suspending him through the end of the school year. This was in September. His foster mother said he was a great kid, wanted him to stay in her house. He got along well. There was another child in the foster care placement. The foster mother testified, and the hearing officer testified. This was a disaster. And this is one we finished. The hearing officer went back to his office and walked back up immediately with the pre-printed decision. I mean, it was so frustrating. So with the help of another lawyer, we appealed it. We wrote a brief, and then you are allowed to present it at the school board meeting and do oral argument. And I said we wanted oral argument, and shockingly enough, it was the hearing officer that did all of the scheduling of all of this. I mean, the whole thing is so backwards. But the other lawyer and I showed up at the school board, and I argued it, and I made the impassioned plea and told them all of the reasons that I did not think the punishment was appropriate, and everything about this kid and all of that stuff that I just told you. And the school district agreed with me, and they shortened his punishment to suspension for just that semester. So in January, he was able to go back to school, and that it was a huge victory for this kid, right? Finally, somebody listened and thought, man, we're going to help this kid and not throw him out again. And it worked. I'm not saying it's always going to work. Appeals are supposed to be more on the law. But given the procedural defects and some of the facts of the case, it was just a great, we were so fired up about the kind of injustice of this one and what the kid did. Again, he had done it. He had mouthed off, but it was mouthing off. It wasn't even profanity. It wasn't, I mean, he was being kind of like a little jerk, but trying to be cool, trying to make friends, right? Like trying to be funny, trying to be the class clown, trying to make friends. So it ended up working. We don't ask you to do appeals, but I tell you this story to say that if you have a case where you were really fired up, you can consider doing it, and it can have great results for these kiddos. So thanks.
Thank you all so much for your insights, Rachel and Craig. I'd like to take just a minute to introduce you to Michael Waller, the executive director for Georgia Appleseed.
Hey there, thank you, Caroline. I just wanted to just take a couple minutes and talk just a little bit about what you've heard throughout. People have referred to, and in fact, Rachel just did it about, you were there for that child. Someone was there being a champion for that child, and I want to break that down for you and sort of what that means to be a champion for the child or the young adult. And remember, the truth is, and I was a former legal aid attorney, so I got accustomed to losing cases. And so at some point, you're on the floor and you're begging the court to give some relief to your client. You guys won't be in that position, but and you do ask yourself, and you say, "Gosh, this outcome is just not what I wanted. It's not what I thought." I don't understand how I moved the needle for this client. In many cases, you're going to move the needle in a big way that's obvious. You're going to see an outcome that's different. And as Rachel and Craig and Stan talked about, we have data about that. But in some cases, the truth is that the outcome's not going to be great. You're going to have a hard case. You're going to go in there, and the child may end up being suspended or expelled. And so you're going to ask yourself, what difference did I make? And we've talked about that a little bit. Like, in fact, you've made a difference. You've been a champion. Someone stuck up for that child. But I want to break it down for you a little bit into sort of components. There's a fair amount of social science research and growing research about the impact on a person who's caught up in a system like this of perceived fairness. And so when someone who's caught up in a system like this perceives that the system is fair in some way, it will affect their future behavior. It'll affect how they feel about themselves. And it'll affect their future behavior in positive ways. So they might actually be more inclined to follow rules and to feel that they're part of the community that this system is a part of. And what that means is people try to break down, say, how do you create a perception of fairness? And it can be very challenging in a situation like a school tribunal, which will often feel like just an ad hoc, maybe a kangaroo court even, where you just feel like there's going to be an outcome here already. As Rachel said, sort of talking about the hearing officer who walked back to the office to grab the pre-printed decision. So one of the things that you might want to start thinking about, or at least I'll just introduce the idea to you, and I don't want to scare anybody off with this, but when you go and you represent a child and you're willing, or a young adult, youth, and you're willing to listen to them and then tell their story, effectively what you're doing is you're giving them a voice. And that's very significant for people. It actually makes a big difference in how they interact with systems. When you treat and explain, when you explain to your client why the system works the way that it does, and you then enforce the rules on their behalf, you create a sense of fairness, right? And as you're communicating that to your client, they're beginning to see how the system can treat them fairly. As you create a relationship of trust with them, you're beginning to help them understand how they might find trust in the system. And then finally, all of that together, you've effectively are treating a child with respect. And it's those four components. It's voice, it's a sense of, it's treating them fairly, it's giving them a sense of trust, and then having them feel that they've been respected. And when you do that, you can actually change their overall view of the system just a little bit, but that little bit might be enough to help them integrate a little bit more in their school setting and their community setting. And so when they're in a moment where they have a moment of choosing or feeling whether or not they're going to engage in defiant behavior or not, for example, it may make a little bit of a difference. And it will also help them with self-esteem issues and just a general sense that they're not alone in the world. So I just wanted to take a couple minutes to explain that idea of being a champion and why it's significant. And it's not just because we think so, that we think that feels good for them. And it's just something that people have spent a lot of time thinking about. And there's research that shows your impact on these kids is significant, even if you don't exactly win the case as you'd like to. So I wanted to make sure that we spend a moment on that. And so I think to head us out, Carol, am I right? Am I introducing or handing it over to Kaimara Guidry, our Equal Justice Fellow here at Georgia Appleseed, to take us home? Is that right?
Yes, I think I'm gonna close us out. Today has been amazing, y'all. We've been anticipating this day. We've been thinking about it. We've been putting so much work into it. And I really just wanted to leave us with gratitude for y'all spending your Friday afternoon with us. This work that we do, this fight that we're in, it's not possible without you. It's also not possible without our YPC, our Young Professionals Council. And I wanted to give our incoming chair from YPC, Ebony, an opportunity to speak. Ebony, did you want to share a couple words before we close out?
Yeah, sure. Thank you, Kaylin. Can everyone hear me okay?
Yes.
Can everyone hear me? Okay, thank you. I wasn't sure if my volume was up. Thank you so much for this opportunity. I just want to take a little bit of time and introduce myself. I'm Ebony Mobley. I'm the Employer Relations Manager at University of Georgia School of Law. And I just want to talk a little bit about the work that we do at YPC and share with you some information to hopefully pique your interest. As an auxiliary of the Georgia Appleseed, the Young Professionals Council, we have a mission to contribute and participate in law and policy reform, through advocacy by providing equal and fair access to information and services for our underserved and disadvantaged Georgians. In addition to our Tribunal project, which you just heard about, YPC is focused on our Dismantling the School to Prison Pipeline project, where we focus on reducing reliance on exclusionary disciplinary techniques, which, as we just learned, often disrupts the learning process by removing that child from the classroom. YPC has made significant contributions to two subsets within the Dismantling School to Prison Pipeline project. One being our Bridges to Behavioral Wellness initiative. Here we create mechanisms for families, educators, and advocates to assist with the navigation of complex systems, of behavioral interventions and support for children with mental illness, autism, and other intense needs. The other initiative is our Keeping Kids in Classrooms toolkit. This is a comprehensive guide with data and ideas to help parents, community leaders, and other advocates work together with school and administrators and classroom teachers. Now, in addition to our advocacy commissions, I'd like to talk a little bit about a few YPC signature events. One being our annual Martin Luther King Day Service Project. Past projects that we participated in here would include ADL, the Anti-Defamation League, No Place for Hate initiative. We've also worked with Atlanta Trees, Atlanta Beltline Beautification Project. We also sponsor our annual fundraiser event, which we've titled Spellbound. We invite summer associates and other community partners to create teams to play in a Scrabble tournament. And we typically include a silent auction as part of that event, which has, it's always fun to see what is up for auction. Been some great gifts and opportunities there. Our Friendraiser event. This is our annual outreach event to recruit membership to YPC. These are attorneys and non-lawyer advocates. We also award one of our fabulous volunteers a Volunteer of the Year award, which we are so proud to give out to our advocates who have just donated, immense time and efforts towards the YPC. My story. Well, just over 5 years ago, not long after relocating to Georgia, I was looking for meaningful volunteer opportunities. I was introduced to Georgia Appleseed at an event hosted by my former employer. And shortly after that, I attended a Friendraiser event, and that really piqued my interest in the YPC. I was introduced to the then YPC president, Craig Friedman, who assured me through, a couple conversations that, this organization can benefit from non-lawyers such as myself, as a partner in our mission, and the rest is history. I've been a YPCer ever since. What keeps me engaged and excited about the work we do? It's certainly the people. you know, the amazing talent and knowledge that we have within the council, and also the results. You know, seeing tangible results for Georgians is definitely a huge motivator, and I'm so excited about continuing on this mission. So if you're looking to develop your career, exercise leadership, and expand your professional network, please reach out to Micah and me, Micah Moon, that is, and me, or any of the other YPCers on the call today. That'd be Craig Friedman, Stan Hill, or Rachel Platt. I'm going to place contact information in the chat, and I hope you will consider joining the YPC to share your expertise, your experience, and your passion for advocacy. Please feel free to reach out to me at any time. I'd be happy to talk with you and answer any questions that you may have. Thank you so much, everyone.
Thank you, Ebony. Thank you. Before we go, I want to share a couple of opportunities that we have for you to get involved. Obviously, we talked a lot about the tribunal process, and that's one of the main ways that you can get involved with helping to keep foster youth in school and in class. But that's not the only way that you can volunteer your time with Georgia Appleseed. We're always looking for help with research projects, writing projects. We have a host of resources, and we're always looking for help with developing or editing our research, our resources, our community resources. So we have a help guide. We have a couple help guides that are available, and we are always looking for help with those projects. We do interviews, we do listening sessions. We're very committed to hearing the voices of the communities that we serve. And so we always need help for those types of endeavors as well. Caroline, can you go to the next slide? We try to make it really easy for you to get involved. On our website, there is a pro bono interest form that you can fill out. So you've heard all these amazing tips and tools and learned all these skills today. And we want you to be able to put them to use by volunteering to be a part of our Tribunal Volunteer Lawyers Network. And so on the website, you can find the sign up form. In addition to that, my project with Equal Justice Works actually is expanding Georgia Appleseed's impact and work into another area where we will be supporting LGBTQ youth in care. And so if anybody that is on the call with us today may be interested in helping out specifically as it relates to us gathering information or any projects while we're developing resources for LGBTQ youth, you can also fill out the interest form for that as well. If you have any questions on how to join the fight and come along with us, feel free to reach out to Caroline, our legal and policy director. You can reach out to me as well. I'll put my contact information in the chat box. But other than that, I really just want to say thank you. Y'all have been very interactive throughout this pretty long training on a Friday afternoon. And so we appreciate you. And we look forward to working with you and helping to keep Georgia's most vulnerable youth in school and keep those schools safe and just. So thank you so much for joining us.
Thank you all so much. Have a great afternoon. And if our panelists will stay in the room, that would be great.